Can we... All right. No, we will. All right, good morning, colleagues. We welcome the SIU. I see the deputy head of the SIU is here. Good morning, ma'am, and your team. The chairperson of the SABC board and his team are here. Colleagues, we are meeting this morning for what I do not anticipate to be a long meeting if everybody has done what they are supposed to do or doing what they are supposed to be doing. So we should be having an early day today, given the fact that the House will be meeting not at 3, but at 2, because the President has called a special joint sitting. So we have lost already an hour in terms of any work that we would have wanted to do. And I think we are still recovering from last week. Maybe I can just say first off the bat to the SIU, we've been meeting with the municipalities, as we had indicated in our interaction on ESCOM, that would also be meeting with the SIU. With the municipalities, on those municipalities that had received disclaimed or adverse findings for 3 years or more. Well, I can tell you now that there's big problems there. The committee is still to finalize its report, but there is no doubt that if we do not pay particular attention to municipalities, to governance, to the MFMA, and due process, consequence management, tender management, contract management, fruitless, irregular, and wasteful expenditure, the whole 9 yards. And so, given the fact that we are in the process of devising modalities on us referring cases or issues for investigation to you, the first point of call would be those municipalities. So I just want to put that, if you can, we'll flag it, we'll finalize on our side. But it's something that if you can also start applying your minds to, but we are extremely, extremely concerned about the state of health of those municipalities. Notwithstanding, of course, that there's 48 others which the AG had flagged, but these ones in particular are of serious concern to us. So at the appropriate time, we would really appreciate that we sit down and talk about how we move on those ones, because there's the trend is the same, the themes are the same, the shortcomings are the same. It's just different players, but they're all singing off the same hymn sheet. And so those municipalities will be prioritized. I think when we have our second run to tie it down, we will please be there. But in the meantime, I'm sure that you can just start reviewing what we have done and the issues, and we can give you the list of those municipalities and start looking at them. I know there are capacity issues that you may have in terms of resources and so on, but that crop of municipalities whom are a perennial headache, what we can only call problem children, really. We must be prioritized. And there are, of course, in just 4 provinces, Northwest, Limpopo, Free State, and the Northern Cape. We're not saying it's good everywhere else, but in that particular space of those municipalities, we are concerned. And the role of COGTA is not assisted. So it is something that we would want you to look at. But that was just for us to dispense of our own housekeeping with the SIU. Colleagues, if there are any apologies? Mrs. Dombi, any? All right. SABC, any apologies that you want to flag? SIU?
Morning, Chairperson. Morning, honorable members. Advocate Mutibi will be joining us in a few moments. If I may comment, Honorable Chairperson, on your issue about municipalities, I recall that also in the last interaction that we had with this committee, you did mention that the committee was worried about municipalities, and we undertook that at an appropriate time, we will come and brief you on the municipalities. There are a couple of municipalities where we are conducting investigations across the country. It will also be useful for us then to receive the list of the 48 municipalities that this committee is particularly worried about. And we will go back then and look at the requests for investigations if they relate to any of those municipalities, and also then update the committee in terms of where we are in the event that if we have a proclamation or ongoing investigation in relation to any of those municipalities.
Okay, no, that
All
is
right.
fine.
So be guided by you in terms of when
right.
we should avail ourselves, but we will commence with the preparations.
All right. Parliament is going to recess tomorrow. So in the next term, we will prioritize that interaction. I'm sure the list can be handed over of that 12 so far that we have engaged. Ms. Kabende will hand that over to you of the ones that we have already met because we had hearings last week and we finalized yesterday. All right, colleagues, let us get to the work of the day. We're going to get off the bat with the SIU, and then the SABC will come in, and then colleagues will be able to interact with that particular, with the presentations that we had also received. We thank you very much for being here this morning. So let's hand over to, colleagues, are you fine? All right, to the SIU.
Thank you, Honorable Chairperson and Honorable members. I will then do the presentation. Going directly to page 2. Page 2 just sets out what the content of the presentation will be. We will focus on providing the committee on the project milestones. As you may be aware, the investigation was conducted in 2 phases, and there's phase 1 and phase 2 of the investigation. I just want to pause then and welcome Advocate Mutibi, who I mentioned that will be joining us.
Advocate, well, we were advised that you would be joining us, so we are in your hands in terms of who's speaking. Yeah, as long as we get the information.
Yes.
Yeah.
No, thank you very much, Chair. I really apologize. I was informed that we are scheduled to start at 9:30, and the invitation also indicated 9:30. So we were not, or at least I was not informed that we'll be starting early, but when I got the call this morning, I rushed.
No, thank you. We will
Thank
look
you.
at that. Thank you for rushing. No problem at all.
Thank you.
Right, SAU, you can continue. We are in your hands. Saki, may I humbly ask you, sir, to close the door for us?
This one here. Honorable Chair and honorable members, I really thank you very much on behalf of our team. I'm greatly indebted to the Deputy Head for starting the process. I see that on the slides, it it shows the contents of our presentation. And as I walked in, indeed, the investigation is divided into 2 phases, and will take the committee through those phases. The next slide deals with who we are in the sense of our mandate. which is derived from the Special Investigating Units and Special Tribunals Act of 1996. And this Special Investigating Unit was established by Proclamation R118 of 2001. SIU is a public entity that conducts its investigations through the mandate or authorization by the proclamation, as would be signed by the President. Our vision is that we would like to be the state's preferred and trusted forensic investigation and litigation agency, in a sense that we do accept that there would be those competitors of ours in the private sector space, but we want to believe that we can do the same, if not the best, for government. Our major functions are derived from the legislation, which is really similar to other law enforcement agencies. Major functions on the left-hand side is we investigate corruption, maladministration, and malpractice. The niche that we have, which is really what we have control on end-to-end, is the institution of civil proceedings. We've got the powers that are listed in the middle to execute our function. Out of our mandate, and we will take through on some of the outcomes, we do not have the powers to arrest or prosecute. If we need that to happen, we then liaise with the NPA and obviously the SAPS. We also refer disciplinary matters to the state institutions. Part of this presentation looks at that. We also work closely with other relevant agencies. So this being our mandate and our background and where we derive our mandate, we also have prepared a new strategy within which this presentation and the investigation on SABC was also executed within the framework of the new strategy, which is not materially different from the past, but it emphasizes on the outcomes. Emphasizing on the outcomes and emphasizing on consequence management and prosecution and civil litigation. And we will take the committee through those outcomes. Right, the next slide really just goes into the proclamation that authorized the investigation into the SABC. I need to just put it on record that what preceded the proclamation is the information that came out of the ad hoc committee that was looking into the affairs of the SABC. We also engaged with the SABC board prior to the proclamation in terms of gathering the information that is required to investigate the allegations that were received. And we then put together the proclamation that went through the process and they were signed accordingly. Proclamation R29 of 2017, that's the one that really authorized the overall investigation. We have since issued an interim report and on the 21st of September 2018, and we are anticipating the final report in around February of 2020. And as we investigated based on that proclamation, we then received information from the board relating to allegations of irregularity around a security contract. We engaged with the board. We also looked at various information that we got, and we then prepared an amendment to the then proclamation because this contract was not covered in the scope of the original proclamation. That proclamation was signed off and we investigated. As a result of the urgency around this matter, being that the security arrangement could be affected if this investigation of this contract is not executed swiftly. Also, because the SABC is one of the national key points, we wanted to expedite the investigation. With that in mind, we then investigated, issued an interim report, and the final report has also been submitted. We will take the Honorable Committee through the outcomes of that investigation. The line at the bottom of the slide is really to say during the investigation, we received good cooperation from the SABC board and the officials who were relevant during the investigation. As we indicated when we started, we adopted a phased approach, phase 1 and phase 2. This presentation summarizes the outcomes of the investigation into phase 1, and will also provide an update on the status of all phase 2 matters covered by Proclamation R29 of 2017. We'll also present on the additional proclamation that I referred to on the security tender. If we go straight into those matters that were investigated in phase 1, as I indicated, that some of these matters that we investigated, they also emanated and were identified during the ad hoc committee inquiry, and all of those contracts that are mentioned on the slide number 7, we did find evidence that indicated that there were irregularities in the awarding of these contracts. It's Vision View Productions, Sikela Kabiso, Lona Vision, Laser Consulting Economics, Trading as Infonomics, Asanta Sana, and Foxton Communication and Mott McDonald. We do summarize what each contract was contracted for in the next slides. We also obtained evidence that indicated that there were irregularities in the awarding of what was called success fees to the then Chief Operating Officer, which is Mr. Mutswening. We also investigated some of the appointments and salary increases that were effected during his time, and we found that there were irregularities. We'll take the committee through that. There were some of the findings that were made by the public protector. We also found evidence really supporting that some of those findings relating to staff increases or staff appointments were irregular, and there are names that are indicated on some of them, and we will indicate later on what their positions were. In some of the instances, we really found that there were no irregularities and that the appointments were done in accordance with the policy. Slide number 9. As a result of the investigations conducted by SIU, we, based on the findings, we then prepared court-ready evidence, and in respect of some of the matters, and there's about 45 matters as per the outcomes in the investigations. Just to indicate to the Honorable Committee that most of the outcomes, as we investigate, if we find that the contracts were awarded irregular, it is our duty by law to institute civil proceedings and with the aim to recover what the corporation may have lost. And we then set the contract aside, obviously through the high courts at the moment. Once the contract is set aside, we also request the court to order a just and equitable outcome, which would see some of the monies recovered. There's also referrals to the NPA, and these referrals come as follows. If during the investigation we find evidence that points to criminal acts, we are required by law to take that evidence to the National Prosecuting Authority for prosecution. There's also outcomes that refers to the disciplinary process. When we investigate, if we pick up that any of the officials of the corporation are guilty of misconduct, we then refer those matters to the accounting authority, in this case, the board, but we also notify the executive about the matters. And we then work closely with the corporation to ensure that there's execution in those matters. There's about 10 civil litigation matters instituted. In some, in fact, most of those matters, the SABC would have already initiated the process, and we would then request the court for SIU to join the proceedings, and we'll indicate in all of those. There's about 11 criminal referrals and 24 disciplinary referrals. In all of these referrals, as I indicated, we work closely with the corporation to make sure that there's execution. We have implemented some measures to ensure that we follow up on this and make sure that we enable the execution of these outcomes. On the civil litigation side, because we have realized that we experience a delay in the ordinary courts, there's a process that was initiated so that the special tribunal can be reestablished. And that tribunal is in the process of being established through the Department of Justice. We are at the stage where the rules and regulations of the special tribunal just needs to be signed off, and the minister will sign them off. Once that is done, the tribunal will then be up and running. So what we will do once the tribunal is established and functional, we will then engage with some of the parties in the litigation process so that we can take some of these matters to the special tribunal. That is a legal process that we will engage in. On the prosecutions, we are engaging on an ongoing basis with the NPA to ensure that there's priority given to most of these cases, including the SABC cases. On the disciplinary matters, we also, as I said, we support the corporation and we make sure that there's appropriate follow-up. Where there's support in terms of evidence or witnesses, we ensure that we provide that support. The investigation has produced evidence to initiate or join civil litigation instituted in the name of SIU and SABC in the High Court, and these are about 10 matters. The value of the litigation matters, and the value is derived from the contract value, is just over 560 million. And as I indicated, that all of these contracts, we have evidence that indicates that they have been irregularly entered into. So our view is to seek to set this contract aside and then seek to have a recovery of all those monies that the corporation may have lost, subject obviously to the legal process and the orders that the courts will make based on the evidence that we would have presented. There's one matter where we provided evidence for the matter of Asante Sana. We'll come back to that. The claim of that matter is about 350,000. The next slide deals with what we refer to as the success fees. These success fees, our evidence reveals that these would have been the fees paid based on some of the official work that Mr. Motswening would have done in, call it, negotiate or arranging the contract with MultiChoice. So, in our view, is that those success fees have been paid irregularly to Mr. Motswening, and there's evidence that we are ready to present to court based on that. So, we and SIU and SABC have jointly issued summons on the 5th of February 2018 in the High Court of South Africa, Gauteng Local Division, against Mr. Motsoeneng. The civil case consists of two claims, as I indicated. Firstly is the so-called success fees, and the second part is the part relating to the prejudice, pecuniary prejudice that the corporation may have suffered as a result of the irregular appointments and the irregular increments and suspensions and unlawful terminations of employment. We've quantified the claim to just over 10 million, and that forms part of the litigation process. The papers have been served, and as we indicate lower down on the slide, the civil process is underway. There's a case number provided, and Mr. Motsoeneng is defending the matter. So we have until the 20th of September, which is a day after tomorrow, to file some of the court documents. We've got our chief legal counsel here. If need be, can add on, but this is an ongoing civil litigation. Unfortunately, we have to abide by the court processes. But what we are doing, Honorable Chair and Honorable Members, because we understand that the quicker the matters are resolved, the good for everyone, particularly for the corporation that needs this money direly. We have engaged with the judges' presidents across the high courts to assist with what they call case management. So they institute that case management in a manner that seeks to avoid unnecessary delays, either on the part of the applicants or on the part of the respondents. So once the matter goes to court, they would have then case managed it such that any of the legal impediments are dealt with upfront. So, and we are seeing results of the engagement, such that some of the matters are enrolled. We've got some of the court dates already. So even before the special tribunal is in place, we do engage to seek speedy resolution of these matters. The one agreement that we now talk to is the one relating to audit services. We have engaged into the civil litigation together with SABC against Sikala Kabiso to review the contract and set it aside. This contract was entered to on the 3rd of October 2016. The value thereof is about just 9.8 million. And we, as SIU, successfully joined the litigation. As we indicate there, the notice of motion was issued and the process went on. This case has already been heard. So the review application was dismissed on the 14th of June, but we have filed for leave to appeal and on this matter, because we believe that there's a prospect of success on appeal. So we are waiting a court date on that matter. In respect of other contracts relating to this company, evidence that we obtained indicated that the deviations that were made did not meet the requirements of the SABC supply chain management and also of the PFMA and the requirements of the Constitution. In that regard, we make appropriate findings. The next contract that I refer to is the contract relating to the company called Vision View. That contract was to build a multi-purpose studio. We obtained evidence, again, that indicated that this contract was irregularly procured. And as a result, we got into a civil process to get it set aside. The monies that were paid up to the date of the institution of the litigation was about 34.4 million. The total contract amount is 52 million. Again, this matter has already been heard. So we are seeing, based on the engagements with the High Court's judge presidents, that they, one way or another, are able to assist the process. The matter was heard, and on the 9th of November, we were successful in the judgment, and it was handed down by the High Court, setting the contract aside. However, the court made a ruling which we do not agree with. The contract was set aside, but when it came to the just and equitable, which is really where we would like the recoveries to be ordered, the court ordered that aspect to be referred to an arbitration in terms of the agreement between the two parties. So we are saying, if the agreement has been set aside, we cannot have some of the aspects that are still applicable. So that's really the basis, and we will argue that in court. So we have taken that aspect on appeal so that it doesn't set a precedent which is not going to help us going forward. And the company has filed an application. We are informed they seek to introduce new evidence, and that is subject to a legal process. So we are anticipating that that process will also be concluded appropriately. The next slide, we've also instituted the civil litigation against the former SABC executive, James Aguma, and Lorna Vision. This contract was entered into for purposes of collection of TV licenses. In this regard, the SIU submitted evidence to the SABC attorneys in support of the civil claim to recover an amount of 62.7 million. We issued summonses against both parties, and the SIU has been given leave to join the proceedings. Again, there's legal process that's going on. There's amendments that were due, subject to that legal process, and the deadline for those amendments to be filed is today. So our chief legal and the legal of the corporation will have to ensure that we meet the deadline. We will explore, as I indicated, avenues to expedite these matters by engaging with the judge's president so that the matters are expedited. The next slide deals with the matter of fruitless and wasteful expenditure against, again, a former official of SABC. The name is Bessie Tukwane. Our records show that she was the acting COO. We are claiming for liability for fruitless and wasteful expenditure incurred cost in the award of the Vision View contract. That is the one mentioned in slide number 13. Summonses have been issued against this. There's two officials, and we'll indicate later on what happened to Mr. Padeachi. We are reported at the time of finding out that he is out of the country, and we are monitoring the situation once he gets back into the country, or we're saying it at the end of that slide. There's legal process that's going on, and we will also ensure that this matter is also expedited. I'm informed that the value of this claim is about 42.3 million. Again, on the same basis, we'll seek to expedite this matter. The next slide deals with the one on economics. This contract, our evidence reveals that it was awarded for the commercialization of SABC digital strategy. We also found evidence that indicated that there was an upfront payment, which we are of the view that it was not due. We applied to court to declare the contract invalid and claim the damages suffered by SABC. Again, as I indicated, that the court process is underway. The company is opposing the matter. We will indicate the value. The value of the matter is about 4.5 million. So we are informed, although the case has been now scheduled on the roll, honorable committee members and chair, the date that we were given is 14 May 2020. So for us, that's the part that we really cannot control because it's based on the court roll. But we are of the view that once we have our own tribunal for these matters, that will alleviate. There's also a civil matter that we have instituted against the then acting Chief Finance Officer. The name is Audrey Rapela. The claim against is for the unlawful authorization and approval of Mr. Motswening's personal legal fees, as well as the upfront payment in terms of the appointment of the Infonomics company. I'm informed now that the value of that matter is just over 20 million. So in this regard, we sought, as we always do, that we think every time of new ways of doing things. We realized that where there's a possibility of recovery against, I would say against anyone, but in particular, if it's against the officials, who choose to leave the organization in the face of consequence management. We also considered the issue of laying a claim on the pensions. And this is one of those cases where we sought to say it almost works similar. The principle is the same as the asset forfeiture unit principles. Because in the asset forfeiture unit process, you would seek to freeze the assets even before the matters are heard. And then when the process is concluded, you would then, based on the court order, will then forfeit. So in this regard, as I say, the principle is similar. We thought it would appropriate and prudent to freeze the pension just so that there is an opportunity to recover. So once the pension is freezed, the legal process will take its course, and once it's concluded and there is a court order, we can then lay claim to recover the monies to the corporation. And we will seek to do this in any appropriate instance, any appropriate case that we deal with. In this case, I'm informed that based on the legal process, the documents have been exchanged between the parties. There was a pre-trial conference that was scheduled to take place a day before yesterday. So I'll seek to find out from our legal team what transpired. Hopefully, it transpired well so that the matter can progress to hearing. The next slide is the recovery against a company called Mott McDonald. The SABC, in this regard, our evidence reveals that they unlawfully procured the services of this company to revamp the lifts. And the value of this matter is about just over 7 million. As I said, in many of these cases, the corporation would, out of its own accord, have initiated processes to set this contract aside. In this case, the SABC brought an application to declare the contract invalid. We also brought a joinder to join. So this matter has, again, been enrolled. We're really seeing traction from the court processes in enrolling these matters. The matter has been enrolled on the unopposed roll for the 21st of October 2019. And we are expecting a positive outcome. Honorable members and honorable chair, that sees a conclusion on the presentation on some of the civil litigation matters. And what we have realized is that the investigation on those matters has been completed, and we have referred evidence to court. We are instituting action to recover on behalf of the corporation, jointly with the corporation. Where there were officials who were guilty of misconduct or any other infraction of the law, we have referred those matters to the appropriate authorities, be it NPA or if there's a need to discipline these officials. So we are seeing traction in terms of holding people, though, or officials, and those private companies. We're holding them accountable for the irregularities that may have been committed. We are now entering into that aspect of the referrals based on the criminal evidence. In terms of our law, when we investigate and find that there is a criminal action that has been committed, we are required to refer that evidence to the NPA. And our legislation says once the matter has been referred to NPA, it has to be dealt with in the manner that serves the public interest. So we've engaged with the NPA. The common understanding, and even out there in the public's expectation, is that once matters have been referred, they should be acted upon. We have engaged with the NPA. We are seeking to find out what the decision is. That decision should either be to prosecute or not to prosecute, but what we are looking for is a decision, one way or another. If it's a decision to prosecute, indeed, that is really first and foremost what we would like. If it's a decision not to prosecute, we will also sit down and understand what were the shortcomings based on the evidence that we have collected. But of all those referrals, we've referred about 11 matters to the National Prosecuting Authority. To date, there's one matter that was enrolled as speedily as we wanted to see. There's one matter relating to one executive, and that matter relates to the fraud, and the slide number 19 deals with that matter. This person made herself guilty of fraud relating to the bursary scheme of the corporation. So we will give an update on where the matter is later on. In respect of other 10 matters, these matters involve criminal referrals on the companies who contracted with SABC and some of the directors and of eight former SABC executives, and including some of the directors whom evidence pointed out that there's been unlawfulness. We also quantified the values around these criminal matters. Because in terms of the Criminal Procedure Act, there is a process at the end of every matter where the court could also rule that the accused person pay back the monies that has been lost either due to fraud or any other criminal action. So we are seeking to see that that clause in the Criminal Procedure Act is also invoked in the process. We are glad, though, have been informed by the NPA that they have provided a dedicated prosecutor to deal with the SABC prosecutions. This is based on our engagements with the NPA to ensure that there is traction and these matters are attended to. We are hoping to see positive action out of that. Slide number 20 deals with NPA referrals still relating to the success fees paid to Mr. Mutsuning. The evidence pointing towards criminal offense committed in respect of the payments of the success fee, there's against 2 SABC officials, 1 current officials, and 2 board members, former board members, have been referred to NPA.
Advocate,
Yes.
I don't mean to interrupt you. I think for consistency, because we've been naming everybody this far, let's continue on that trajectory. So if the names of those in the meantime, of the 1 official and the 2 board members, because I think we've been naming people as we go. So
Indeed.
yeah.
Chair, may I just indicate that in cases where we have put names on the record, or on the presentation, is those instances where action has been taken, or criminally they've been charged. In cases where they've not been charged, or the matters, in all of these civil cases, the court papers have been issued, so they are public. So we're able to mention. So in some of this, in the one criminal matter that we are mentioning, it's because the accused has been charged. So the matter is in court and is public. So in some of these matters that are not yet in court and not yet public, we would really plead with the committee that to guard against the legal risk that we may incur, that these individuals really not be mentioned. The investigation has also produced evidence in support of about 24 disciplinary referrals out of the investigation. We're giving update on where what happened to all these referrals. The impact of these referrals has been that there's a few executives or an official that have exited the corporation. 2 have been found guilty of disciplinary charges, 1 dismissed and 1 resigned. 2 resigned in the face of disciplinary, and the other 1 contract expired and not renewed. Can we also just mention to the Honorable Committee that where officials resign in the face of any action that's taken against them, the only relationship that resignation terminates is the employment relationship. Because of that termination of employment relationship, the corporation cannot take an action as an employer, because there's no employer-employee relationship anymore. But where evidence points that the individual could be followed on a civil process, though the resignation does not help them with that. The resignation also does not help them with criminal prosecution. So we will then still follow them on that basis. The next few slides really deals with.
Sorry, Mr. Chairman, just if I may interrupt here. Here we've got a case where people have been disciplined and so on. So here names could be given to us.
Yeah, I'm sure. Right. On slide 21, the investigation has produced evidence to support the following 24 disciplinary referrals. And then it goes on to say the evidence implicates 14 officials whom have all been charged.
Yeah.
Involving 7 SABC executives and 8 SABC officials. So,
thank you, Chair, for that. There's an opportunity in the following slides
all right,
where we're naming the officials and what outcome has been. If we go straight to slide number 22.
All right. Are we fine, colleagues, with that? All right. Thank you. You can continue.
There's an official called Kubendran Padayachi. This person was the acting group executive. His actions, or the disciplinary process related to his conduct relating to the Vision View contract. And we were informed that he resigned in the face of the disciplinary process. There's a case of Suli Mutweni. That's the part. She's also been charged criminally. She was the group executive of sport. She's been dismissed. The former acting chief operating officer, Besi Tugwana, her contract expired and was not renewed. Simon, or her action related to Vision View. Simon Mulaudzi, who was the head of procurement, his action related to all those three: contracts, Vision View, Sekela Kabiso, and economics. He's been dismissed. The former acting chief financial officer, Audrey Rapela, also the information we got is resigned in the face of disciplinary action. This is the instance where we have managed to freeze the pension fund, and the freezing was done legally through the court process. There's another official, Anand Mutlia. This was the group secretary. He was found guilty, but we are informed that a final written warning was issued. Sifiwa Mulaudzi related the action relating to economics. She was the group executive of commercial enterprises. She was found guilty, and again in this instance, we are informed that she was given a final written warning, but we are informed that she's currently on suspension as a result of other SABC internal process. So some consequence management is still continuing, despite. There's a person who was the general manager of supply chain management, governance, and special projects, Ayanda Mkize, action related to economics. She has been dismissed since. So Chair, we're really seeing traction in terms of what we call consequence management. So this is the trend that we would like to see, and we are engaging with the accounting authority, being the board, just so that we are kept informed about how our referrals are being acted on. The next slide relates to the criminal case that we instituted against Suli Mutweni. As I indicated, this is one of the matters really that were taken through to court as speedily as we wanted to see. However, the status of this case is that, towards the bottom of the slide, the criminal trial commenced on the 4th of September 2019 and was postponed to 30 January 2020. So we're continuing to monitor the process just so that there's appropriate outcome. The recovery of the amount that was lost, it's about 45,000, will be dealt with as part of the criminal proceedings. Chair, the next slide deals with one of the areas that we needed to investigate, which was the MultiChoice. Slide number 27. The investigation revealed that certain provisions of the contract have been unlawful by virtue of being in contravention of the government's prevailing. We are informed that it is actually referred to as the Broadcasting Digital Migration Policy at the time, as well as against certain provisions of the Broadcasting Act. When we investigate, we found that the contract has already expired. So to take the process forward and take it to court would be futile. But however, there's evidence also that indicates that the signatories to that agreement were, as at the date of the signing of the agreement, not duly authorized to sign it, and that a false or incorrect resolution had been compiled in this regard. In this regard, appropriate action will be taken. This aspect of the investigation is still underway. Appropriate action will be referred based on the findings. Either it's against the executives or the accounting authority members who were in place at the time. We're also of the view that in respect of the financial viability of the expired agreement, the evidence obtained indicated that it was financially viable at the stage of entering into the contract. This is probably from a business perspective. However, there were some losses that the corporation suffered in this regard, and that aspect is also still under investigation. There's reference to a new contract that the corporation entered into, although it was really not part of the scope, but we looked at it to check whether there is a base to either amend the proclamation to include it, but we didn't find that there's evidence that necessitated that. That concludes our presentation on phase 1. We now enter into the phase 2. And I go straight to slide number 31, which indicates some of the focus areas of the investigation. The investigation covers TNA. It also, because this contract was scoped for the second phase, but again, based on the agency that I indicated earlier on, we covered the security contract, and based on the amendments.
TNA
also
would refer to the new age.
Sorry?
TNA would
Yes.
be the new age.
Yes.
All right.
Oh, thank you for that, Honorable Chair. It's the new age indeed. We also investigate irregular appointments of officials, irregular payment of bonuses to senior managers. There's some payments which allegedly, the allegations we received that were paid irregularly. Some irregular expenditure relating to tax matters. There's a SARS penalty, which if due care was taken, that penalty would probably not have been incurred. The investigation will look at that. Some clearance, tax clearance certificate, validity issues that we need to look at that, and then we'll also look at the conflict of interest of the corporation officials. There's further allegations on page 32 relating to some payments to the 53 artists about the Legend concert, SABC Heritage or SABC Thank You concert to the tune of 27 million. There's also a Rapid Blue X Factor Season 1 irregularities regarding the lease of some office in Nelspruit, irregular payment of Mr. Mutwening's legal fees of about 1.2 million. There's also various allegations that we have received relating to Northwest SABC offices, those related to the appointment of the general manager, provincial news editor, officials doing business with the SABC. This relates to the conflicts of interest. We're also investigating possible corruption and abuse of SABC resources. The next slide, slide number 33. With regard to TNA, when we commenced with the investigation, again, the SABC board had already taken some steps on this matter. And those steps resulted in the contract being cancelled. But however, we were informed that TNA was taking legal steps to recover from the corporation to the value of about 144 million. So We also entered the fray in terms of assisting the corporation, and we give some details in the next slides. The security contract, as I indicated, we've already finalized it, but we talk briefly to it later on. This new age breakfast, as we said, Chair, the investigation is ongoing on this matter. However, the facts and circumstances pertaining to this contract having been skewed deliberately in favor of TNA, those aspects will be investigated, in that it deprived SABC of the revenue that was being made from all of this breakfasts that were held. And we are of that view simply because there were some sponsorships that were paid, and those sponsorships, our preliminary finding is that they were paid by some government departments and state-owned entities. So what we will do, because they're not really covered by the proclamation, the last bullet point on slide 34 is that we are considering to apply for a proclamation to investigate all of these sponsorships. However, we have been contacted by the State Capture Commission on this aspect. But the nature of the discussion is such that they would like to understand what is it that we are focusing at, what is it that they are focusing at, just so that at all possible there's an avoidance of duplication. We were scheduled to appear at the State Capture Commission. However, the chairperson of the commission indicated that it's not prudent at that time for us to appear, but we continue to engage with the investigating team at the commission. Slide number 35 really just goes into some of the observations that we have to date. That the contract entitled TNA to sponsorships, in our view, those were exorbitant amounts paid by state departments. Those enabled this breakfast shows, and the revenues, all of them accrued to the TNA. As we indicated, they instituted arbitration against the corporation, which we joined to then defend the corporation. And with a view to defend this, the SABC brought an application to have the contract reviewed and set aside. We also joined in that matter. However, there's an issue that really presents some legal questions in terms of what would happen to the TNA. Are we not likely to come back with a hollow order from court simply because there's liquidation processes? In this regard, our chief legal counsel indicates to me that that is not an impediment. We will proceed with the litigation process, even beyond the liquidation, if there's assets that we can lay our hands on based on the legal framework that's applicable. As you can see there, that there's a liquidator who has been appointed, so there's dealings with that liquidator to ensure that the interests of the corporation are also taken into account during this liquidation process. The security contract, slide number 36. Again, I need to underscore that this matter is also in court. There's litigation pending. We have joined that litigation, but I suffice to say we have found that the contract was irregularly awarded, and also we found that there were financial misconduct on the part of the officials and some of the members of the accounting authority, which are the former directors, and we have referred those to appropriate institutions, including the NPA. We have briefed our counsel to join the process. We will obviously seek to have this contract set aside. The proceedings were already underway, having brought by the company that did not get the contract. However, we are in their prayers. They are of the view that they should be awarded the contract. Well and good, that is their right to pray like that to the court. But we are of the view that the contract is irregular. If the court declares so, this is not our view that it should just be given to the other company. This process must be done properly, must be started afresh. In this security contract, we've already submitted the reports to the president, and the presidential report has been made available to the corporation. It was also required as part of the court process. In all of these processes, Honorable Chair and members, we look at the responsibility of everyone involved, and in particular, the role of the accounting authority, which is the board. In instances where we find that there's irregularities and that the board had not executed its function in accordance with the applicable law, we make that finding and make the appropriate referral. So this slide essentially indicates that in all of the investigations that we have conducted, depending which accounting authority was in place, if there's a pointer that any of the irregularities points to a certain accounting authority, will make finding relating to that accounting authority. So as we conclude the investigation, we are also going to have a focused investigation around the governance space. And this would indicate to us what the governance framework was or is, and if there's any governance inefficiencies, how is it that they could be remedied or how they could be improved. That aspect of the investigation is underway, and we'll conclude it well before the final report, and we will engage with the accounting authority based on that. The last slide, Chairperson, really it's a summary of the outcomes that we have presented. In summary, on the left-hand side is the civil litigation instituted. In 10 matters valued to about 560 million. Contracts that were set aside successfully, valued at about 114 million. The next block refers to the NPA referrals. We've referred about 11, and there's one asset forfeiture unit referral. The next block is about the evidence on misconduct. We've referred all the cases to the accounting officer or accounting authority. The next block relates to our interaction with other regulatory authorities. It could either be SARS or Institute of Directors or any other authority that we need to engage with based on our findings. We have already submitted an interim report based on the overall investigation that was submitted on the 21st of September 2018. And on the security contract, we acted on it. We have completed the investigation, and the final reports were submitted. Honorable members and Honorable Chair, that is the end of our presentation. Thank you very much.
All right. Thank you very much to the SIU. I think that for the purposes of getting the global picture, let us hand over to the chairperson of the board, Mr. Makatini, and we welcome him and the CEO and the team who are here, and then we will then take questions. Honorable Deputy Minister, welcome. Mr. Chairperson.
Thank you, Honorable Chair. Greetings, honorable members, Deputy Minister, SABC Board, and the executive team. Receive my greetings. We appreciate the opportunity and the presentation by SIU. We're working very close with the SIU. A lot of the matters they've investigated were initiated by the SABC, so their presentation covers quite a lot of what we are doing. But I do want to give honorable members and the chair a comprehensive picture of how we are driving consequence management and what are the things that informs the work that we are doing in the area of consequence management. And the main goal there is to recover monies that were stolen and also to make sure that we restore governance. And in doing that, we're basically dealing with all legacy and governance issues. There's quite a number of input that is helping us with those efforts. One is the Public Protector's Report of 2014. So that report highlighted a number of things that needed our attention. And the remedial action coming out of the Public Protector's Report are binding on our side. So it's not optional. We have to implement those. The second report that is also informing the activities around consequence management is the ad hoc committee report, which was the exercise done by Parliament. The third one talks to the Auditor General findings. So Auditor General will come and audit and highlight a number of things or lapses that need to be attended to. That's a third input that is informing consequence management. SIU, of course, the presentation that you've just been taken through is a fourth input to that. But the last one, which is also very important, is our own internal forensic. In the last financial year, the internal forensic team worked or produced about 180 forensic reports. So I'm giving you that so that you can have a comprehensive picture that we're not only limited to what SIU has investigated, but there's a whole lot of other input that is helping us drive the issues of consequence management. And you may have seen, honorable members, in the media, negative news about the SABC, and I just want to put that into context, that as you follow through and try to hold people accountable, as you dismiss people, suspend people, or investigate for what they've done wrong, they will fight back, and they are fighting back. You may have seen round about June that our chief audit executive was almost killed in an attempt which we strongly believe is as a result of the work that we are doing. So in terms of the key executives that are in the forefront of fighting corruption, driving renewal and rehabilitation of the SABC, their lives are under threat because there is a very strong fight back. And they're working with some of the media people to undermine the work that we are doing. But we are committed, and the executives are committed to do what serves the best interest of the corporation. In all that we're doing, I do also want to make sure that honorable members are comfortable that processes, procedures, and our own policies are being followed. So when we hold people to account, when we discipline people, we are making sure that when we're doing that, we observe and adhere to our own HR policies. So nothing is being done outside of that policy. But of course, there would be noise out there, because if people have been just enjoying eating, stealing without anybody holding them to account, they will try to fight back. So ensuring sound governance framework and instilling sound internal control is part of our key strategy, key pillar of our strategy. So this has become part of the new turnaround strategy for the SABC to make sure that we ensure that there is sound governance. And it is part of our continued effort and commitment to deal with the systematic collapse of governance in the SABC financials and to basically deal with all the issues of corruption that have engulfed the SABC. It also affirmed the SABC's board commitment in consequence management. We have to hold people to account. It is the right thing to do. But also, there are those of our employees who've done their work with diligence, with integrity. And when they see no action being taken against those who have been found to be implicated on wrongdoings, they are expecting us to take actions and to make sure that we do what is necessary. So we are dealing with, intending to deal with all the cases that the SIU has investigated. So everything that the SIU has presented, we are working on those, and we are addressing those issues. So a lot of these things are historic matters, but It is important for us to deal with those legacy and governance issues, but make sure that we put systems in place to ensure that there is no reoccurrence of some of these issues that SABC has been faced with. So that will be my opening remarks, and I'm going to request Advocate Vanara just to give you some input, and then you will be followed by the HR executive, so that we can fill you in terms of the other cases that we are dealing with and give you more details, so as to make sure that we have a comprehensive picture coming out of what the SIU has presented.
All right, no, that is fine. Mr. Chair, is he speaking to this presentation here? Or is that another presentation? It's the only one I have is this one.
Thanks, Chair. The idea was really to speak to that presentation. But as you would have read through the presentation, as well as the presentation given by the SIU, it is a carbon copy because we're doing the same thing. What I would like to do, though, is perhaps piggyback on the SIU presentation, but highlight some slight variances insofar as it is applicable to the
Are you
SIU.
presenting another presentation or not? Like, do you have anything? Because I want to make sure that members are following. So is there a presentation on what of the piggyback?
It is the same SIU presentation, Chair, but I'm going to refer to the relevant, I'm not going to go through the same presentation, but there are certain areas that I'm just going to highlight where there's slight variance.
All right, it's fine. No, let's do that. It's just that one would have hoped that that presentation would have been circulated because it makes it easy to follow. Because as you say, your presentation that we have received is a carbon copy of the SIU. So if there's annexures or additions, it would have been preferable that they would have been circulated. It makes it easier for members to prepare as opposed to receiving things raw. So I think but it's fine. Carry on. Members will, if you just need to stop the advocate on the way, just do so that he can clarify the issues. But I think it will be helpful in future. All right, let's carry on. Over to you, Advocate.
The point taken, Chair. On the SIU presentation, Chair, if we can just go to page 8. It's page 8. 8, yeah, that's the one. The last sentence there that says the SIU found no evidence to support allegations of irregularity regarding the appointments of other officials. 2 weeks ago, Chair, we had a meeting together with the SIU because in our view there were certain officials that the investigation reports had indicated that they were not irregularly appointed. We had a discussion around this issue because in our view, some of those officials were irregularly appointed and that they were part...
Sorry, Chair, to interrupt. Sorry, Chair. See, Chair. You see, Chair, the SIU has presented a report. The advocate is coming now and presenting another report and then picking out things out of that report and saying, no, it's not entirely correct. We had a meeting with the SIU 2 weeks ago. See, Chair, that is not for, that kind of discussion is not for us here. They should go and meet with the SIU, discuss those things, clear it up and present one report to us. It's very uncomfortable that you're coming and now picking on the report certain things that is not correct. You also tidy up your report, meet with the SIU and then present to us. We don't want that kind of thing there. That you will now go to the report and say, no, this here was not like that. We had a meeting, we changed it. Go and sort your business out and then bring it to us. because now we don't want to go through that. Now then we'll start getting involved in that discussion too now about what is correct, what's not correct.
All right, Honorable Somi and Honorable Hadeb with an H, and then we'll just tie it down on this one.
No, thanks, Chair. I think it's in order that indeed SIU made investigations either on behalf of the state in general or on matters that matter for public good. In such an instance, the engagement with an authority has taken place. Of course, there might be issues that they won't be happy with, but it's not within our purview to deal with such, as we have in front of us the report of the SIU. And we sought to follow that trend as an authority which does the investigations. Because we run a risk here that there might be some matters that are indicative, pointing a finger to the board. And they would come in this instance to punch holes within those matters, and it won't be assisting us in terms of having to delve on such areas. One example which I would be interested in, if we would move towards that angle, I will come later on in terms of such
fine.
indications. Thank you very much, Chair.
Honorable Hadebe with an H, and then I'll tie it down on this one.
No, thanks. No, I'm covered, Chair, because my interest on the exact same matter was to get an understanding of how many are those cases, not to open another investigation, whether or not there are issues outstanding, and also to get an indication that now these cases are done and dusted. You have satisfied yourself with the investigation.
Yeah. No, I see. I that's why I asked the issue, is there another presentation? And I deliberately allowed us being referred to a page because I wanted to see where we were going. I don't think it will be proper that the SABC now wants to respond or react to the SIU presentation. I don't think it's for the SABC to do that, nor is it for us at this platform. Where there are areas which are a work in progress, rather we indicate those. Should a question about it arise, we say, no, this is a work in progress. But when we now start having a dialogue, because then the SIU will rightly say, right, Chair, we want to respond to that. And then now we sit here and watch a towing and froing. The SABC, if it has a presentation, it must present its presentation. That opportunity is available. And then we will take it from there. But let's not walk down that road of, I think the introductory remarks of the chairperson of the board were sufficient to speak about cooperation and the action steps that they have taken and the issues that he is raising about consequence management, which is in order. The presentation by the SIU is to the committee, not to the SABC. So Advocate, I would request that you rather, I think, speak to your matters where there are discrepancies with your, that for us it's a work in progress, and then you'll indicate those, because initially you said, and we agreed with you, that the report is a carbon copy. Because when I read it, now if it's a carbon copy, then there's no discrepancy. Yeah, so let us rather do that. So we'll hand over back to you with that caution that we are giving.
No, thanks, Chair. I'm well chastised.
No one's chastising you. We're just clearing process, clearing the woods. There's no chastising.
Chair, let me state on record that the presentation by the SIU is exactly the same presentation of the SABC. And I confirm the accuracy in respect of the developments around both presentations. With regards to slide 12 on Sekela Xabiso, the SABC did not appeal the judgment, not because we disagree with the views that are held by esteemed colleagues at the SIU, but it was for financial reasons. That's the only reason we did not appeal. And if the appeal is successful, it's got the same benefits for the SABC as it will have for the SIU. On page 13, around Vision View Productions, which is a multi-purpose studio, I want to confirm on record that the SABC started using the studio from the 1st of April 20...
Just 1 second, Advocate. You said slide 13.
Yes.
Who's operating the... Can they be consistent with that, with what we are, with the pages being referred to, please?
Yes.
All right, thank you.
So this is a multi-purpose studio, Studio 11. We have been utilizing the studio since the 1st of April. The SABC, prior to the legal dispute arising, had paid 34 million rands. It had not been utilizing the studio pending the SIU investigation as well as the legal process. And after the judgment that was delivered on the matter, we had sought to engage. You would have heard Advocate Motibi referring to the matter having been referred back to arbitration for what would have been a just and equitable order. Because arbitration itself involves finances, we had sought to have this matter resolved out of court. However, our efforts to settle this matter with the relevant service provider failed, and the SABC is also appealing that judgment on the basis that we need to get clarity around whether or not we need to pay, and if so, what will be a just amount to pay. If we go to page 16 of the presentation, around economics, you would have seen from the report that in this matter, this is one of the matters where the SABC and the SIU are not the same applicants or the respondents. The SABC consciously decided not to oppose this matter because this transaction, in the view of the SABC, is an irregular transaction that ought to be set aside. So we agree with the course of action that has been taken by the SIU in this regard. On page 17, which really talks to the freezing or interdicting of pension interest, I want to point out, Chair, that there are a number of these matters that we are approaching the pension fund of the SABC, initially to try and not incur legal costs. We approached the pension fund to urge it to use its discretion to, without a court order, withhold the pension benefits that are payable to the member, because at law, the pension fund has got an obligation when the pension interest becomes due and payable to a member to pay that money to the member, unless, of course, there is a court order. In certain instances, we do succeed in persuading the pension fund as an independent body with its own board to use its discretion. But in certain instances, we do get difficulties necessitating us going the court route to get interdicts in the process, incurring legal costs.
But
I thought
just on that, Advocate, how sustainable, therefore, is this arrangement, if I may call it? Because it has no basis then, because it's discretionary. I think I think you may want to clarify us there, because the term discretion makes it optional. So if you can, but there's just 1 second, there's a hand. We'll come back to you, Advocate.
Chair, I'm just getting a sense that we are now writing his report for him. Because on every page that is referring us to, and if he's saying that he agrees on the SIU report, that is the same report. For instance, now what he's saying to us is that the SIU has freezed this particular person's pension fund. But now he's telling us that it might not be the case because of their policy. So now we're busy taking notes. We in fact writing his presentation here. So I would request that on every page that he has an issue or something to add on, they must quickly sit somewhere and do that, Chair, because now we're referring to pages, but if he's saying it's the same thing, it's not the same, because what he's saying now is not what the SIU is saying. Instead, he's trying to explain to us that in an investigation where the SIU has been allowed to freeze this particular employee's pension fund, but now he's telling us that according to SAPC policy and not what, it might not be the case because of this policy and that. We are going to end up being confused because the matter on this page is telling us that a court has allowed the SIU to freeze this particular pension fund. So now here we are not going to be sitting and listening to the SAPC telling us why it might not be and why it might be. Right. We can't be writing his presentation, Chair. It's incorrect.
All right. Let's wait. Let's hear these nuances that he's giving, because you see they adding a context which we may not have had. So you see, because now we are duty bound to look at the whole arrangement of the freezing of pension funds and payouts, because I noted it here as well. Yeah. When does it apply and when it doesn't? Now there's the term of discussion. So I crave your indulgence for us to be patient, a teeny weeny bit longer, and hear it out. Let's hear these punctuations, and then you will have time to interrogate. But I hear the concern of the members. It's valid, because I still maintain the SAPC should have had a presentation. That's the bottom line. But I plead with you, colleagues.
My clarity is that, is the SABC only interacting with this report for the first time? And didn't they have an opportunity to interact with SIU if there were areas of concern, so that they iron out all these issues before coming to us?
Okay. Mr.
Were that opportunity not presented to them? Because when you read on slide 4, it says the SIU can report that it has received very good cooperation from the SABC board and officials during the above investigations.
Okay.
What is coming out from SABC speaks contrary to what is contained on slide 4.
Okay. All right. Okay. Oh, we are on track. On track, Mr. Chair. Let's hear from you.
Thank you, Chairperson, and thank you, honorable members. As the SAPC, we engage with SIU on a frequent basis, so we are fully aligned. That's why when the chair asked that our presentation on the SIU matters is a copy of what the SABC, of what the SIU has presented. So what we're trying to do was to try and give honorable members a comprehensive picture, because if you look at the SIU, they dealt with specific issues. There are other matters that we've dealt with, but maybe for the sake of progress, let's maybe engage in questions, if there are questions where there may be gaps or there may be need for clarity coming from the SABC, let's do it in that manner. But we are fully aligned with the SIU. There's no disagreement.
Okay. No,
Thank you.
That's fine. Colleagues, let's do it this way. Advocate Varara, how far do you have to go? How much more do you want to add? How many more?
This was the last point, Chair.
All right, tie it down, because I still maintain, let's hear the punctuations and the nuances. They will help. But I think it would have been proper for the SABC to have had these things put down, pen to paper, on the specific matters, because you see the frustration of members is now having to follow and make additions to a presentation that's not the SABC presentation. That is where the shortcoming has arisen. But I think that, be that as it may, I'll look for another, tie down the issues that you wanted to raise, and then I will come to you, colleagues. Okay, we're good? Right. Progress.
Thank you, Chair. On the last issue, we, together with the SIU, obtained the interdict to stop the pension benefit being paid to Mr. Audrey Rapella.
Okay.
There is no contradiction there. All I'm saying is there are other similar cases, and the process, not necessarily the Audrey Rapella matter, but other instances where we need to get a similar arrangement. That is the process to follow. The discretion, Chair, you asked the question. It is a legal discretion. They have a power in law, the Pension Fund, in terms of Section 34, capital D of the Pension Fund Act, to exercise judicially so. So in the event that they think that there are circumstances that entitle them to exercise that discretion, they do. In the event they hold a different view, they decline the request, and then we ought to go to court to go and obtain a court order. I must reiterate, the nuances that I'm highlighting, I could well have said them in respect of the same carbon copy presentation of the SABC. It's just that I thought, which proves to be an inconvenience, that dealing with a presentation that has already been tabled, it will be easy. It was not meant to create any conflict, because no conflict whatsoever exists. Thank you, Chair.
All right, thank you very much. Mr. Chair?
Thank you, Chairperson. My suggestion would be that maybe let's allow you
But it says that you had cited somebody else who must...
to avoid maybe getting into a similar kind of challenges. I'm proposing that we engage on questions. If there are specifics from an HR perspective, then Mr. Tekiso then can assist.
Right, colleagues, may I make this suggestion? Let us get HR to express themselves. I think let's allow that, because we might as well cover the grounds. We already knee deep in this kind of arrangement. Let's hear what HR has to say. And colleagues, I'll beg your indulgence again that if it's punctuating anything, let's allow it. But the point has been made. There should have been a presentation. All right. HR?
Thank you, Chairperson. Good morning, honorable members. Good morning, Deputy Minister and colleagues. HR confirms the presentation from the SIU in terms of consequence management that has been taken. We also can confirm that where we have to, we've actually gone so far as to interdict retirement benefits of those employees. And Chairperson, in addition to the cases that the SIU have mentioned, which have been referred for disciplinary processes, we've actually done so in as far as those matters are concerned. And, in addition to those, there are about 9 matters, that we've proceeded with, where the employees have either resigned, retired, dismissed, given final written warnings or warnings. In some instances, we are not pleased with the outcome of the sanction based on the infringement.
1 second. Let's not speak in generic terms.
Okay.
I think be specific now on those cases, particularly the ones that have arrived at a conclusion or in progress. I think in the meantime, pull out that presentation so that we speak in specific terms. Because, so I'll give you the opportunity to formulate that so that we speak specifics, and then we'll take it forward. I think, Chair, that would be in order. Mr. CEO, then I'll come to you, colleagues.
Thank you, Chairperson. Good morning, honorable members. Sincere apologies for this confusion, but we did submit a presentation. The reason why the presentation is identical to what the colleagues from the SIU have presented is because we work very closely. You will see, for example, the details on the employees that are going through consequence management. Those need to be submitted to the SIU, and that information is derived from us. So we have submitted the required presentation, and I think what the colleagues were trying to do was just to re-emphasize and highlight some of the issues that may not have been covered. But it is exactly the same presentation because the information submitted is from the SABC on all of those cases. Right. Thank you, Chairperson.
No, that's fine. On see the printout here, and I can't get my soft copy of this. On your slide on referrals to date, Disciplinary's investigation has produced evidence to support 24 disciplinary referrals. I think those are the ones we are referring to HR. So can we get the breakdown of that? So I think what we should have done was that SABC should have spoken to their presentation and refer to the pages they wanted to expand on. I think when it started speaking to SIU, it raised the eyebrows. So on the 24, I think that's the one, unless there's more. So is HR ready one more time?
Can we project the presentation?
You ready? All right, let's get a briefing on the referred cases. So then it completes the whole picture, and then we... Okay. All right, let's just allow the 4IR to run its course there. Just, come on. All right, there we go. Order, please. All right, no, it's fine. All right, let's...
Okay.
All right. Can that also just be submitted to our administration, and then we will take it from there? All right, over to you, HR.
Thank you, Chairperson. We now have the list of consequence management cases from the SABC. I'm going to take you line by line, Chairperson, honorable members, so as to give an indication as to how far we've come. You will note that on the first column, we're indicating the name of the employee, and that's Iris Cupido. And the source of the investigation was the SIU. And the employee used to be with SABC Foundation. And Chair, you will note that the nature of offense, whilst on one hand, it's about the outcome of the investigation of the SIU, we also have added, in most instances, the infringement coming from the SABC. So on this one, the offense was irregular awarding of bursaries, inclusive of gross misconduct as well as gross negligence. The employee was found guilty, the contract was terminated, and the matter is closed. Sorry, Chair. I think I was in the middle of my, okay. So and I'll come back to Iris Cupido. So Ayanda Mkhize was an employee within the supply chain management process, and the source of the investigation was both forensic, our own internal forensic function, as well as the SIU. And the infringement was irregular, improper, unlawful appointment and payment of Infonomics. And I'm sure, honorable members, you've already been exposed to Infonomics from Advocate Mutibi's presentation. The employee was dismissed on 17 October and referred a dispute of alleged unfair dismissal to the CCMA, and the matter is still at the CCMA. The second one, Chairperson and honorable members, was a gentleman called Zaki Rawood. The source of the investigation was SIU. It was gross negligence in terms of the offense, dereliction of duties, gross dishonesty, and failure to act in the best interest of the organization. The employee resigned in the midst of a disciplinary inquiry. The next employee was Tandegan Dlovu, and the source of investigation was both internal forensic as well as SIU. The infringement was irregular, improper, and unlawful appointment and payment of Infonomics. The employee was not found guilty. The company took the matter on review, and the employee proposed a settlement which the company has rejected. The matter therefore proceeds at the CCMA. The next employee, also referred to by Advocate Mutibi, is Mr. Simon Mulauzi. He was, or the source of investigation was the SIU as well as our own internal forensic department. And he was based in SCM, or in finance, and the misconduct was contravention of the provision of SABC rules and personnel regulations, as well as PFMA, as well as Treasury regulations. The employee was dismissed and subsequently lodged an unfair alleged dismissal dispute with the CCMA. The next employee, Anand Mudlia, also referred to earlier by Advocate Mutibi, is in the company secretariat. And the infringement was gross negligence, dereliction of duties, gross dishonesty, and failure to act in the best interest of the company. The employee was issued with a final written warning, and the matter was closed. Next employee, Ms. Sulim Sweni, also referred to by Advocate Mutibi. The source was both SIU and forensics.
Chairman, may I interrupt? I'm terribly sorry to do this. One of the comments that I think you highlighted was some of these outcomes you weren't happy with.
Yes.
Could we get an indication on each one whether there was happiness or unhappiness?
All right, no, that's fair. That's fair.
Okay, thank you, Chairperson. Sulim Sweni, she was at some point a group executive in sport. Failure to disclose interest, failure to obtain permission for additional work, conducting private business using SABC resources. The employee was dismissed, and of course the organization is satisfied that the infringement, the sanction meets the infringement. Audrey Rapela, also referred to by Advocate Mutibi, source of investigation, both forensic as well as SIU, also in finance. Irregular, the nature of the offense was irregular, improper, and unlawful appointment and payment of Infonomics and unlawful appointment of staff. improper appointment and deviations of Sekela Qabiso and Infonomics. The employee resigned at the DC, and as was referred to by Advocate Mutibi, there's civil litigation as well as pension fund benefits being interdicted. I've already spoken to Iris Cupido, and I indicated that the employee was found guilty and the contract was terminated. Nomsa Piliso was the group executive of television, and the source of investigation is the SIU, and the infringement was gross dereliction of duties, contravention of delegation of authority framework, which is our DAF, and contravention of supply chain management and preferential procurement policy. The outcome was that the employee pleaded guilty for infringements committed, and a written warning was recommended. The organization was not too happy with the outcome, but accepted the outcome.
Were there any recoveries that were due from her?
Not as yet, Chairperson, because subsequent to that, whilst the employee was in our employment, there were additional charges, that would have been proffered against the employee, but they decided to resign. And the issue of recoveries is a matter that that the organization is looking into right now, because this is a recent resignation, as early as 2 months ago.
Well, I would imagine that that should have been then factored in there.
Okay.
That's the issue, because then it gets lost to us.
Yes.
If I'm looking at the nature of the offense.
Yes.
And then I'm looking at the action update, and I'm just thinking, yeah, but it's fine if that addition can be made. All right. Right.
Okay.
2 seconds. HR. Yes.
Thank you, Chair.
Then I'll come to you, Honorable Tolash.
On your irregular expenditure note, under the same person, Sekela Qabiso, you also mentioned that for the SAPC to draft condemnation reports, there was no handover report from, I would suspect and imagine, is it from the same person? Maybe if you can also add that under the mentioned Mr. Qabiso.
All right, no, that's fine, Honorable Tolash. Yeah?
Thank you, Chairperson. I'm worried the HR says they did not follow up until other charges were put to the same person. I'm very worried with that gap, Chair. If there were no new charges put to the person, it means she was going to go scot-free.
Yeah.
And I'm worried with now the internal process that the SAPC was talking about. Maybe when they come back, they must tell us how strong it is, if it can allow this to happen. I'm very worried, Chairperson.
Yeah. No, I share your worry. Actually, that's why I was raising that matter, because it just. All right, HR, continue. I just hope that's noted on that particular one. Right, we can carry on, sir. We got number, yeah, that's the one.
Thank you, Chairperson and honorable members. The next employee is Filimilwa, and the source was both our forensic as well as SIU, and the employee is within our policy and regulatory affairs. And the nature of the offense was gross dereliction of duties, contravention of DAF, and contravention of supply chain management policy, contravention of clauses of the executive terms of reference. The employee was found guilty, and a final written warning was issued.
Did those offenses there result in any losses to the institution? I mean, contravention of supply chain policy. There was no losses. All right.
No, Chair.
All right.
The next employee, Charles Mungale, the source of investigation was forensic as well as SIU, and the employee is based in our provincial office in Northwest, The nature of offense is unauthorized communication with media, failure to take disciplinary action against subordinates regarding sexual harassment, unauthorized use of company property. So this is both an infringement investigated by both the SABC as well as the SIU. And this matter is still proceeding, in terms of us engaging with the CCMA at Northwest Province. The last employee, Tabile Mtsweni, is in finance, and there's a breach of PFMA and failure to inform. Sorry, Chair. Tabile Dlamini.
Okay.
And the source of investigation is SIU, and the division is in finance. There's a breach of PFMA and failure to inform National Treasury of a deviation. The employee resigned prior to charges being preferred, and there's a process to interdict the pension fund benefits in this regard. The employee resigned a month ago.
Okay.
And Chairperson, thus far, this is what the SABC has been able to do and what we've been busy with and are currently busy with in terms of the cases referred to the SABC by the SIU.
All right.
Thank you, Chair.
That's fine. All right, colleagues, I think that it's fine. Mr. Chairman, is that all? All right. I keep deferring to the chair because he is the one who's, so I must always make sure that they're implicating him correctly in the things being said. All right, colleagues, let us interact with the presentation and the editions of the SABC. All right, we'll take maybe let's get a member to raise their issues completely. So 3 questions at max. All right, Honorable Van Minen, Honorable Tolashe, okay, let me, Van Minen, Tolashe, Hadebe with an H, Honorable Somio, Honorable Swartz, Honorable Liz. All right. Okay, Honorable Machau. Okay. And then Honorable. All right, colleagues, let us jump right into it. Right, Honorable Van Minen, you've got the floor.
Thank you. What I want to find out from the SIU is the special tribunal. How is that put together, under what legislation, and what are its powers and jurisdiction, as well as what can it find? So I really want to find out about that, as well as why the decision was to form a special tribunal rather than use the civil courts. Thank you.
Okay. Right, Honorable Tolashe.
Thank you, Honorable Chairperson. Honorable Chairperson, I'm quite impressed with the extensive presentation from the SIU. I guess, Honorable Chairperson, we should make SABC as a flagship in dealing with the rampant corruption that took place in SABC, at SABC in particular. There's one time when everybody in the country was like, the government is not doing anything with the rampant corruption that was taking place at SABC, and now I'm quite impressed with the progress that has been made. I hope, once again, Chairperson, the SIU can be able to take the country on board on the kind of work that they are doing. Because I can imagine the anxiety with the South Africans now is the fact that even though the people have identified that there's corruption that is taking place, they suspect that there isn't much that is taking place in dealing with corruption. And that anxiety is creating problems, because once the nation doesn't trust the organs of states, then we're going to have problems. Hence, people are on the streets on a daily basis. I'm quite impressed with the progress, Chairperson. The NPA should be louder. I mean, the SIU must be louder with the kind of good work that they are making. I'm also impressed, Chair, with the IGR that is taking place at that space where the government is working together in making sure that we deal with this. The case in this, with working with the Department of where there's an establishment of the tribunal. I'm happy with that. I hope, Chairperson, if there are any frustrations that might exist, if that can be quickly brought to the relevant committees in Parliament, so that Parliament can also assist in making sure that those are being removed, so that we can get some fruit out of the establishment of the tribunal. Chair, the SABC must convince us how strong their internal forensic program is, given the fact that we have already identified some gaps, and whether also that exercise is not unnecessarily taking money away from the SABC that is cash strapped, given the fact that the SIU is in their doorstep doing a lot of work. Is there a need for a forensic investigation by SABC, especially for cases that are already with the SIU? I might not understand, forgive me for my ignorance, but
No,
I really would
it's
want to
valid.
hear.
There's no ignorance.
Chair, the last one. The SABC is raising the matter of the lives of the executives that are doing good work within. We have a very bad experience in South Africa. We kind of create an impression that there was never a situation where a person's life was taken because of the such. I hope they've taken note of that and they've done what they are expected to do, so that we don't lose more lives whilst people are doing the right thing, Chairperson. They should avoid that as kangawabenokwazi. We don't know how, because these people are quite very, very dangerous, but we wouldn't want to see other lives lost because there's now a cleanup in the SABC. Chair, I wouldn't want to get into the detail of the work because I don't want also to be seen putting our hands into that, but we must appreciate the work and also call upon all other, through your office, other committees to really rally around this process, so that at least by beginning of 2020, we need to see some positive outcomes in dealing with corruption, and SABC being a flagship in making sure that government is doing something about corruption. Last one. The delegation of SABC is a man-only kind of delegation. I'm not sure what explanation can Chairperson give at this day and time in South Africa. This is bringing more than 5 men with him. I'm not sure whether it's the correct representation of South Africans, Chairperson. Thank you very much.
All right. Honorable Hatebe with an H.
No, thank you, Chair. You said we must ask maximum of 3 questions.
Yeah.
Okay.
I know it's difficult for you, but
yeah, no,
at
it's
least
fine.
try.
No, let me. I'll try, Chair, and you'll also guide us whether or not we are.
We can always take a second round. It's okay.
Okay, cool. Let me start with the first question on slide 8. I've touched on it earlier on. I'm interested to understand how many appointments where you found no evidence to support the allegations of irregularities. Chair, I'm raising this to the extent that such has a potential of creating a toxic working environment where you will have employees who will feel that they are being victimized or targeted. So I'd like to get an extent of, if it's a small number, then it's okay. But if the extent it's too much, then we also like to get an understanding what will then be the way forward from the SABC to make sure that that does not create a toxic working environment. That's number 1, Chair. My second question will be on slide number 19. 19. Out of 11 cases. So are you saying to us that all 10 matters of companies, directors, and executive, all those have not yet been charged since May. I'm raising this based on what you've alluded to, that these matters ought to be treated in a manner that serve the interest of the public, and once referred, they must be acted upon. So I'd like to get an understanding that out of 11, only one a case where you're saying that particular individual has been charged, and you are able to also give us the name. So these executive directors, we don't know who they are, and we did not get a sense of what might be the delay. But you've made an undertaking to expedite the process. The second last, Chair, it's on slide 11 and 14 in relation to the deadlines of the 18th of September and the 20th. I'd like to get a sense whether or not have you been able to file. Today it's the 18th, and you made an indication that on the 20th also you'll be filing. And the other one, it's on the, you were supposed to do what? A pre-trial on the 16th. Has that happened? If I can get an understanding on that one. And then, Chair, okay, the last one. Last one. Let me just get my notes, Chair. Yes, it's on slide 12.
Slide 12.
Slide 12. In relation to the review that was dismissed, I'm interested in understanding, Chair, that the SIU is reviewing or is appealing on what basis, seeing that the SABC is not interested in the appeal, and on what basis was the case dismissed?
Right.
Was I captured correctly?
Yes,
Thank you,
you
Chair.
are. There was a response, of course, on the Cellular Klabiso matter that the SAPC cited being cash-strapped. So they are in agreement with the appeal, but they do not have the resources to. But they will explain further the circumstances of that. All right, Honorable Somyo.
Thank you, Chair. Thank you, Chair. In appreciation of the report, there are just a few matters for me for clarity.
Okay.
The first one of those deals with this. You see that the three critical instances of SIU work. One is on the civil, the other one is on the criminal referrals, other is on the DC referrals. On the DC referrals, I've got about 24 matters, and they have been confirmed by the SABC. I want to check from the SABC side, are these the only DC matters that are on the radar screen of the SABC as we speak? And secondly, we would look into the fact that the informing basis for these investigations by the SIU are on the proclamation number 29, R29 of 2017 and 2018. And on the 2017 one, then there's been addition of a matter which goes to 2018 security contract. And the board chairperson refers to these matters as legacy matters. And therefore their interest is to wipe all these ills that are in the back of the board as the authority. I would love to hear from the board itself on this security contract, the 2018 extension, you see by the President's proclamation, as to what is their initial take on the actual contracting of that security company. And if that is the case, as confirmed, they are in agreement with the SIU's findings. On the matters that have been identified, there might be necessarily matters of the board's decisions. What would be the board's action on such an instance? The third matter is on the multi-choice matter, which SIU has made reference on the fact that the contract has lapsed. And since the contract has lapsed, they see no need to pursue any legal aspect of it. I don't know whether would they view that after their determination that the contract was somewhat finalized in an irregular form. Is that not the basis for pursuing any irregular contract, irrespective, because such companies do exist, and if there's been any financial loss on their own existence, there could be some areas for litigation to be pursued going forward. I see that the strength which I support in terms of the other matter that relates to a company which is under liquidation, there is a vigor to pursue that, and this is a living company, why the same energy can't propel the SIU to do the same with MultiChoice in terms of pursuance of such irregular contract end. And then on the last area for me, Chair, is the matter that relates to the instances of litigation, whether on the civil, specifically on the civil side, that there would be enlisted such matters that have been pursued either by SIU or both by SIU and SABC, and the initiator at times being SIU and SIU being a joinder in some instances. Why primarily the authority itself, which is a primary institution, couldn't see it fit in some instances when such matters have been determined to move with such civil matters. And you'll find that in some instances, SIU pursue such matters as a lone soldier in a way. Does that give any strength into the factor that the board, in its own pursuance, in reality, of wanting to create a reputable image of SABC to begin to be involved in any other matter which has something to do with the image of the SABC as both a broadcaster and the institution which ought to show the side of reputation in terms of the public face. One would like to know in such instances to determine as to whether the primary driver on such litigation matters would be probably closer to what my colleague has indicated here, that the interest of SABC to be visible at all times, not to pick and choose on some instances where it would want to be involved and others not to be somewhat involved. Thank you, Chair.
Okay, thank you very much. Honorable Swartz. Don't worry, I've got all of you on the list. Get Almal Ope list.
He's laughing when you're calling my name, Chair. I don't know, he's got a problem here. There's the whip next to me. Thank you, Chair. On page 14, I'd just like to know, Lona Vision and Aguma, for the TV licenses, they were doing the collection of TV licenses to that amount. I just want to understand from the SABC that ordinarily, when you have such a situation where somebody is collecting on behalf of the SABC and this amount has been collected, how much does the SABC, in terms of percentage, get from companies that collect on your behalf TV licenses? And the amendments, did Lona Vision and Aguma object? As you are saying that if they had not objected to the amendments, then you are going to file by today, which is the 18th of September today, according to your report here. I just want to know, has the Lona Vision and Aguma objected to any of the amendments? And if they did not, are you filing today as per this? And then if the SABC can just highlight us and give us a sense that in a normal situation where the SABC is functioning properly and you have people, and also, in my imaginary mind, I would imagine that this is where you are supposed to drive revenue collection out of TV licenses, ordinarily as the SABC. People must pay for a TV license, and if somebody else is collecting, is there a policy or law that prevents you from collecting yourself, then using consultants that then collect such huge amounts of money? And what measures do you have in place in terms of the percentage that you get? My second question is to the chairperson of the board. If I heard you correctly, you said you have 180 cases which you are investigating internally.
Forensic investigations.
Yes,
reports.
internal forensic investigations, 180 cases. Did I hear you correctly?
Yeah, I'm sure you can just get a quick. Yeah, that's correct.
It's correct. No, I would like to get a sense, Chair, if you've got that huge number of cases, if at a stage you can please submit to the chairperson of Scopa in terms of what cases they are, what are we looking at, how severe are the cases, because if you are doing them on your own, and yet you have this working relationship that is very strong with the SIU, is it viable? Is it cost effective that you are handling 180 cases internally? Not minusing that you can do your own internal cases, of course, but I think 180 cases which are on internal forensic investigation for the SABC is a huge number for that matter. If we can get a breakdown, what type of cases are we looking at, how severe they are, and also in terms of time frames, what time frames have you put to the 180 cases? How old are they? How recent are they? Do you have all that in place in terms of where it is going to take us? Then on page 14, it speaks about, not on page 14, there was an issue of an upfront payment in the SIU's report of 20 million to one of the companies. It's very worrying that in an institution we can have upfront payments of 20 million without any work being done. How many people do sign in the SABC? If we can just get an example for such a huge payment to be approved, how many signatories does it take? Does it go to the board
Are you
for
referring to
approval?
the slide 16?
16 years.
Okay.
Slide 16 years, where we had the upfront payment of 20 million. So just for us to be comfortable, Chair, that there are, as the Chair said, that they are working very, very hard on fixing and implementing clean governance, that when you have upfront payments of 20 million being paid, and how many signatories does it take to approve an upfront payment of 20 million, and who does it go through? Is it just a one-man show? Who approves 20 million for an upfront? So that while you are doing your clean governance implementation, Chair, you take into note that there are these scary things of upfront 20 million payments, so that we understand, is there such a policy that allows upfront 20 million payments, so that we understand that if it's there or not, and because it's not in the notes, but during the presentation, the advocate mentioned it. On our slide, it's not there. I think it was on the slide that he was presenting on, so that we just get clarity there, what actually transpired. Thank you, Chair.
All right. Thank you very much. Honorable Liz, you have got the floor.
Mr. Chairman, it's encouraging to see the progress being made, and so thank you for that, so both to the SABC and the SIU. And so I'm just going to home in a little bit, having given the credit where it is due, and I think it is due. Now, just talking about the MOU with the NPA, why is it necessary to have special treatment for your cases? What is the problem with the NPA? Why is it necessary to go to the judges to get special case management? Is there a problem with the judicial system and you getting around it with special arrangements, and the rest of society is then having to live with the problem? So having said that you've made good progress, there's a concern of the methodology that may be being used. Because if there isn't a problem, why is it necessary to have a special MOU and to approach the various benches around the country and to have a dedicated prosecutor? Mr. Chairman, so, but that doesn't detract from the work that's being done. But it does open a door about the problems we face in the country in the other respect. With regard to SABC, I'm not sure who's going to answer, the chair's leaving, but in terms of the disciplinary cases you've been dealing with, you've told us about a list of cases. Are there cases that you've lost? And what are the costs been involved, and why have you lost them? The Vision View studio, is it simply a case that the studio is great, but you're paying too much for it? Or am I misunderstanding it? I hear you using it, but you haven't paid for it in full. So what actually is the issue there? The tender might have been granted irregularly, but in the end, what are you trying to achieve? You're trying to save some money, or do you want the studio taken away? You don't want it. The SABC, I think you're looking for 350 million bailout at the moment, is it? Something like that, a lot of money. And so the work that's been described this morning is very important in recovering losses and so on. But what about and I think one of my colleagues touched on this, the operations as they are now? The license fee collection, what is that costing? Is there a better way of doing it? But even more important is cutting costs. What actually are you doing to cut the costs of the operations and at the same time boost revenue other than TV licenses? Are you looking at increases in TV licenses? And what are you going to be offering? Is this simply because National Treasury and the Minister of Finance are saying, we're not going to bail you out, so you've got no option. You're going to have to increase TV licenses to not come back next year for an even bigger bailout. Thank you, Mr. Chairman.
All right, thank you.
Mr. Chairman, there is one other. It's a technical thing, and I'm not sure that perhaps SIU can answer it. When you freeze a pension, you eventually take that pension money. That's money that was never taxed in the hands of the individual. It's now not going to retirement annuity, it's going to pay for a TV studio or whatever else, I don't know, wherever the skullduggery took place. SARS surely is going to come after tax on that money.
All right. Honorable Machau.
Thank you very much, Chairperson, and good morning all. Let me add my voice by appreciating the report which was presented here by our SIU. It is for the first time for me to have a meeting direct with them. What I'd like to know from them, you know, when they are here, they are not only here for us to ask some questions, maybe to assist where there are problems that they are encountering as that entity. I would like to know, in terms of the capacity, looking at their core function. You know, sometimes I was once a mayor of a municipality whereby some of the investigations that are done by SIU just disappeared without any implementation. In which cases where issues that are recommended to municipalities are not implemented as such, or in any other, maybe cooperative, whatever. Secondly, how long does it take to put a matter back in the proclamation? Because that can delay a process. If the matter is not covered, but you want to proceed with it, how long does it take? The last one, I'm worried about SABC. How strong are your internal controls? Because CEO made mention that at least they have strong internal controls to avoid a recurrence, knowing exactly there are still rotten potatoes within the SABC. How are you going to curb it? How strong are your internal controls? Thank you very much, Chair.
Okay. Honorable Dirks.
Yeah, thank you, Chair. Chair, I think we need to thank the SIU for this report, and also thank them for the cooperation they are giving Scopa and the working relationship they have with us. I'm saying this here because a week or 2 weeks ago when we had Steinhoff here and we had the Hawks and the NPA here, the Hawks was very eager that they want to pursue criminal charges and prosecuting people. And it was so blatantly clear that the NPA had no appetite to prosecute. And you could see the politics in this whole thing. You could just see the politics at play from the side of the NPA, that certain people must not be prosecuted. So we have serious problems with that kind of attitude as Scopa. Now, with our interaction with SIU, we are pursuing matters without fear or favor, and that's the kind of approach and cooperation we like. Having said that, my first question, I've just got 3 questions. My first question is on page 11. You know, I was, on slide 11, we were listening to Mr. Schlaudi testifying at the Zondo Commission, and then he raised the issue that the SABC actually owes him more money because of the good work he has been doing that day. Now you're raising here at the bottom of this page, you say that on the 2nd of September 2019, Mr. Motsoneng filed a counterclaim. Is the counterclaim related to this extra monies that he said that he believes that the port owes him, SABC owes him? Is that the counterclaim that he has filed? That's the first one. Then the second one is on page 12, similar to the issue that was raised by Honorable Lees, as the cost. You are actually taking this application. You actually the review application was dismissed on the 14th of July, and you are going for leave. You have applied for leave to appeal. Now the amount involved, if I'm correct, the amount involved is 9 million rand. The security company. Now my concern is like you raised earlier on about getting Holocaust orders from the court. perhaps you should look at when you lose a case in court and the amount that you are pursuing, it's not worth the effort to go after it. Then I don't think we should pursue these cases and appeal it and stuff like that, because you cannot throw good money at bad money, you know. For example, if it's $1 million or 2 million that you will recover and then your legal fees is going over R1 million, why pursue it? The courts have ruled in favor of this person. It's maybe just the ones that get away. Perhaps we should not waste too much of energy on those ones and on these appeals and stuff. Some of them we must perhaps just discard it after the courts have ruled in their favor. Yeah, maybe something you need to look at. Then the last issue is on page 14. Now, and I think I have to raise this issue, and I'll raise this issue in every committee, in every department that will come here to Scopa. You raise that you have submitted evidence to the SABC's attorneys. Now, usually when when you write these reports, you just say attorneys, but then you name them, you put them in brackets, you say Werksman. Now, you see, when we say we clean up SABC and want to clean up state departments and government departments, we must clean everything and must clean it properly. Because every 5 years, political leadership in government will change. New people will come in. They'll have their preferences. They'll change you as a board member. They'll put a new president or put whoever he wants to appoint there. So things change. People will put their preferences. And with that comes a host of problems where certain things again start happening. Another group, new things are happening. The point I'm trying to make here is that when we look at, we're dealing with service providers of the SABC that has been appointed. I want to know from the SABC now, when you appoint attorneys as the SABC, do you have a panel of attorneys, or how do you go about appointing? Because they must also go through the procurement, to the supply chain processes. Attorneys must go through the same process. You can't just appoint them. The reason why I'm saying this here is because if you look at this Werksman, in this government of ours in South Africa, you go to transport, you go to central, Werksman is entrenched in government departments in this country. It's unbelievable. And it seems like they've captured government departments. And they also represent senior politicians in their personal capacity. So don't say we want to get rid of the one capture and there's another capture happening on the other side. We need to seriously look at this thing. One firm of attorneys can never be so entrenched in government departments like they have captured them. So this is something that we need to look at. So I wonder if you have a panel of attorneys, because I know that's what we usually encourage in municipalities, because I come from a municipal environment where we put a panel of attorneys out there, and then you use from the panel, where you don't have this thing that one company gets used over and over. Because that's how it all starts. It starts with Werkman, you bring somebody else in, and that's how it starts. So we must say, when we clean up, we must do a proper cleanup. So I just want you to respond to the issue about the panel of attorneys. How do you appoint attorneys? Thank you.
All right. Thank you very much, colleagues. I think the questions have been very comprehensive. So what we will do is we'll start with the SIU, and then the SABC will answer on its components. So you will do a distribution of delegation of responsibilities on the questions cited. So this will finish, and then the SABC can come in on all the issues that it needs to raise. I just want to speak on the issue of Sekela Xabiso, because I think beyond the fact that the tender is questionable, the fundamental issue was why they were brought in to begin with. Because there was a duplication of work. It was work that had already been done, and then they were coming in now to, if I'm not mistaken, to ascertain irregular and fruitless expense work which was already done. So that never sat well with even with Scopa in the Fifth Parliament. The reason, put aside just why they were there to begin with, on its own was an issue. So if you could speak to that. I will come back on the issues of HR and the disciplinary cases, because I think we would want a schedule of all the matters that you have dealt with. Because the other thing is the operative word for this committee is public accounts. So every time we're going to be meeting with an entity, it triggers traffic of information about the particular entity that we will be dealing with. And there are serious issues insofar as HR is concerned and the processing of work. So we'd want the issues you've dealt with, because the issue of the 180 forensic investigations that has been cited, we would, what the outcomes and implementation thereof, what becomes of the findings of those reports, because we've spoken about only 24 referrals here, and I was counting the schedule presented by HR went up to 14 individuals. So where are the individuals or persons arising out of the 180 forensic? What action is being taken in that space? And of course, the cost factors involved in all of these matters. I think SIU, we're quite happy with the work so far that you are doing in this space of the SAPC as we unravel the web of state capture. Because SAPC was at the receiving end, internally and externally, of the well laid out program, to the extent to which the perception is not lost that SAPC became a state broadcast, not a public broadcaster. So we have to unravel that web so that we can re-entrench it to inspire the public confidence for whoever is seeing the SAPC. Because if we don't do that, then these things persist. But to do that, we also need to drill into the governance structures and modalities at the SAPC. Because we may be dealing with the political elements outside, but the extent to which state capture prevailed was that it was entrenched in institutions. And so it's important that we give due attention to that. I want to reiterate the issue of the bailout and the request thereof, and the issue of collections of TV licenses. You know, I don't have a TV, but I'm paying a TV license. And tell me more, I'm trying to get it stopped, which I don't have one. So, but fair enough, I'm paying, all right, good, maybe the SAPC may need my contribution, I'm not sure how far it goes. But what it calls into question is the integrity of the register and the role of people who should be paying TV licenses and the process therein. And so I think the issue about the consultants and the service providers who are doing the work on behalf of the SAPC to collect these TV licenses is important, because you will find that people who should be paying are not paying, and so on. And so you're bleeding revenue there. I mean, every rand and cent counts when it comes to the SAPC, given your problems. And so that particular area is not. So I'm not raising this about me. I'm not bothered. I've given up on my fight with it. It's fine. So it's not. I don't want it responded to me. What I'm raising is the issue of the management of this particular collection, and how it is actually, proceeding. So I think let's get responses to that. I'm glad that the Deputy Minister's here. We will give her an opportunity at the end if there are issues that she would want to raise. And of course, there are issues in the public domain as well, which we'll raise with you that we just want clarity on, insofar as a board member is concerned and the university, just to clear the air insofar as and what action the SABC is taking to track those particular matters. So I think your presence in that regard helps. Finally, SABC, your issue of freelancers, if you can speak to that and the modalities of the management of that particular area and the costs involved. Because in certain instances, you are finding that people are in the office bound rather, studio bound, newsroom bound, and not being dispatched, and a freelancer somewhere. And there's a proliferation of these freelancers. I raise this in the context of the question of cost-cutting measures, and so on. Then there's the funny issue, which I think even in other platforms we have raised. You send a news crew all the way to Destination X to cover a story, and it never sees the light of day on the screens. The costs involved in just transporting people, the movement. So even those things. So the portfolio issue, on so far as freelancers is concerned, whether an audit has been done, maybe I think let me put it that way, of who's who in the zoo doing what, where, and why, and the processes which were followed to get these people into the establishment for SABC. I think it's opportune that you clear these matters for us. And then finally, since you are here, Chairman, rugby. Are we going to be getting the World Cup or not? And well, that's a different question altogether. But if you can just take us into confidence about those things so that you can explain them and they are understood. If there's cost factors which are beyond the SABC, let's deal with that so that we push back on the so-called narratives of blackouts. But I would like to see the rugby. All right, so let's hand over to the SIU, and then the SABC will come in as well and cover its issues. I think, colleagues, we are doing well for time. We would really want to tie down on everything by no later than 12:30. Yeah, all right. Advocate.
Thank you, Honorable Chair, honorable members, and to the Deputy Minister. The question around the special tribunal, under what legislation is it been established and what is its jurisdiction? It is established under the Special Investigating Units and Special Tribunals Act, which is the act that saw the creation of this special investigating unit. That tribunal was established some time back, and we can really check when it was, but it was in the 2000s. But it ceased to operate at some point. And this was as a result of some of the legal challenges that were made at the time around its jurisdiction and some of the technicalities that the legal representatives brought. And it really ceased to operate up to now, I think, well over 10 years, 15 years or so. It was around 2001 when it ceased to operate because of those legal challenges. So when we embarked on the new strategy, which I said really is not materially different from the initial strategy, which was to investigate and make sure that we recover and recover speedily. We then realized that with the case load that we have on our books, which has got the value quantified at about 14.7 billion. If we are to recover as speedily as possible, or as speedily as is legally possible, and looking at the pace at which the cases are going, and I'll come to the honorable member's question around why do we approach the judges. We realized that, firstly, the cases get delayed in the sense that you would have seen one of the matters, the trial date is only given in a year's time. We sat down and said, why is it that we cannot use this legal avenue that's provided by the law to speed up these matters? And some of the lawyers around the table have said there is a purpose for which this legislation provided for this tribunal. And the immediate view that we had was that it can enable us to speed up the process of recovery. So, because it was already proclaimed at the time, as what we are doing at the moment is we are just re-establishing it. And obviously we went through the process. It went to the Minister of Justice, and then it went to the President. In February this year, the President issued a proclamation that seeks to really re-establish this tribunal and allocated the judges around the country in all the 9 provinces. So, yes, it's issued under our legislation. What is its jurisdiction? It's got the jurisdiction similar to a high court. So it can make any order that the high court can make. That's provided for in the legislation. However, there's rules and regulations that needs to be published. Regulations are published by the minister, and the rules are published by the special tribunal president. Those would then seek to regulate some of the processes of the tribunal and so on. So that's the rationale of re-establishing the tribunal, and we're hoping that it would achieve its purpose as was envisaged in the legislation. We take the comment by the honorable member on board that we should take the public on board more around the work that we do as SIU, and we have incorporated that part in our communication strategy. We have in our new strategy a focus on the prevention part of the fight against corruption. And the prevention would entail aspects like raising awareness and ensuring that we have a clear prevention program. And that prevention program, amongst others, is also driven under the anti-corruption task team auspices, but it's driven by SIU. So part of what we are doing, Chair and honorable members, is to ensure that this awareness program takes into account, in other jurisdictions, we've seen that some of our peers in Africa and in some of the Asian countries, they even have a program that goes to the schools. So this is part of what we will do going forward in terms of ensuring that we target the public, more communication of our work, our outputs, but also as part of the overall prevention program. There are aspects of what we need to do. The honorable member also referred to the establishment of the tribunal. So we are hoping that once the rules and the regulations are finalized and published, we should see that tribunal functioning. The lives of the executives, I think this would probably, SABC would respond to that, but I can also comment that we take the protection of anyone that we have to deal with, we take it very serious. We've had instances, and not at SABC, where witnesses have come up and said we feel threatened and so on, and we've taken on board the witness protection program, which is run by the NPA, and ensured that those witnesses are protected. So in any instances, we are ready to support on ensuring that there's security. How many appointments did we not find evidence? I think this is the matter really that occupied the board and the SABC for a while during the presentation. I should just say here that in one of the interactions we had with SABC, this matter came up, and that we presented that to date, the evidence that we have seen does not support the allegations that there were irregular appointments. But yes, the SABC did raise it with us, that we've got a different view. And the teams, and I was informed now that the meeting, yes, did take place, and SABC has presented to us further documentation and information. If we are persuaded otherwise, we will make an appropriate finding. So this is an ongoing engagement, which between the two teams.
I will also ask Edward Kvanara to make a comment when the SABC comes, because he was touching on the matter.
Yeah. Yes. Okay. Slide 19. All the other 10 cases. All the other 10 cases that have been referred to NPA to date. As we said, why the NPA has provided us with an assurance that they are receiving attention. They've even provided a prosecutor who's dealing with those matters. But yes, as we speak today, only one matter has been to court on the prosecution side. So we are in engagement with the prosecutor, and I'll come back again to the question raised: why do we have an MOU with the prosecution? There's particular reasons for that. I will revert to that point. The question about the review of the contract, Sigela Kabiso, the basis for the appeal. The basis for the appeal is that we are satisfied. Well, we have satisfied ourselves based on the legal body of research and the legal view and the jurisdiction that we have gone through, that the Honorable Judge may have misdirected herself here. So we are wanting to ensure that this legal aspect that we seek to get clarity on and appeal against is set even at the highest level of the court, so that it doesn't create the precedents that will impede us in future. The legal position of any aspect of our work is very critical, such that we don't meet with that impediment going forward. If the honourable member wants the exact nature of the course of action, we can provide that.
Right,
but in this regard, yes, the SABC did indicate that it is also will be in their interest if the matter is ruled in favor of SIU in this regard. And then I'll come back to the issue around the economic nature of litigation. You know, we shouldn't chase an amount where we're going to end up paying more and recovering less or nothing. The deadlines of the 16th and the 18th. Okay.
Right, let's.
I think that I also wanted to get clarity in terms of its dismissal. Was it on technical basis or on legal basis? Hence, you're reviewing. So you only spoke about the appeal side. If you get my question. Okay, cool.
I'm going to just hand over now to probably the Chief Legal Counsel, who can expand on that, and also comment on the deadlines of the 16th of September and the 18th of September, and whether we have filed those documentation, because it's important to get that view. Thank you.
All right, can we get that executive summary?
Good morning, Chair, honourable members and Deputy Minister. I'm going to deal with the slides, the question dealing with slides 11, 14, and 17. I'll do it in chronological order. Slide 11 refers to the counterclaim. That counterclaim indeed incorporates a claim for additional success fee. The quantum is approximately 16 million. We will assess and appropriately respond thereto. As you know, the claim, the principal claim is in any event that he should not have been entitled to any amount. If we move to slide...
Just on that 1 second. SAPC, can I request that, because it seems as if the Hlaudi Motsoneng matter or name is going to remain with us for a while. That maybe at some point, which is yesterday, all the issues related to him be clarified in total, because they keep cropping up, and he's at the center of a lot of controversial issues insofar as the SAPC is concerned. And I think we need to clarify that tenure in one way or the other, because it seems as if it's a perennial presence. Let me end there. I don't want to, All right, continue, sir.
In respect of slide 14, the question relating to whether there was, two questions, relating to whether there was any objection. There was no objection to the filing of the amendments, and the amendments has been filed as of today. Relating to slide 17, the pre-trial, the defendant requested a postponement on the 16th due to the non-availability or unavailability of the legal representative and or the defendant. A new date has been arranged, and that is now scheduled for 26 September. That is in a week's time. Relating to the question of the grounds for the appeal, safe to say the following is that the basis for the judgment is in direct conflict with the precedents that has been established in the previous setting aside of contracts. So you will note in the presentation, without referring to it, that 2 contracts have been set aside already. This particular review was based on the same principle, and it contradicts those 2 judgments. Substantively, we are of the view that there is no basis for the finding or for the judgment on that ground, and therefore, hence the appeal. I think I've dealt with all the issues.
Yeah, all right.
On slide 11, the deadline of the 20th, whether or not you are set to file before the 20th. The last paragraph on slide 11, we have until the 20th of September to file replication and a plea to Mr. Motsoneng's counterclaim.
Yes, that will be met.
All right, that's fine. Advocate, you can continue.
Thank you very much, Honorable Chair and Honorable Members. The next question related to the outcomes of SIU, in particular the 24 disciplinaries. Are these the only matters? I think SABC can add on to that, as we have seen that there's probably other matters that they're dealing with. The board's view on the security matter, I think that the board will comment on that. I just made a note around that question, but our view is that the evidence that we have found is that the contract was awarded irregularly, and this is the presentation we will make at court. However, we are mindful, and this will probably come up at court, depending on the outcome of the court. If I make the assumption that it will be ruled in our favor, then the question is what happens? And this is where the business considerations come in and the legal considerations come in around SABC being a key, national key point. And those are the matters that we are aware of, and we will engage with them at the time of finalization of the proceedings. The issue around MultiChoice, Honorable Chair and Honorable Member, we have taken that into account. As we presented, that there's some losses that the corporation may have suffered, and that aspect is under consideration. It's still being finalized by the investigating team, and we will definitely consider if there are any actions that needs to be taken against MultiChoice, we will pronounce appropriately. I see the question around why is SABC not the primary litigant and so on and so forth. I suppose SABC can comment, but what happens at the moment is that we do engage with SABC in any matter. Like in this appeal, we've engaged with SABC. They understand the rationale, and they've made a decision based on how they understand the litigation process. And they probably SABC can comment, but in the comments made earlier on is that there's sort of economic consideration of whether they pursue or they allow SIU to pursue. The issue around TV licenses, Lona Vision, are we filing by today? I think that has been answered. The issue around 180 cases being investigated internally, I think SABC can respond to that. The upfront payment, Honorable Member, the value, and we really apologize that we didn't write it into the presentation. We went through the presentation last night, and it should have really been reflected. The value of the upfront payment, I'm informed, is 4.5 million. The 20 million related to slide number 17, which was the matter against the personal legal fees of Mr. Muzoni. Yeah. And yes, indeed, it is our concern that what was the basis of the upfront payment, because as we have it in terms of the PFMA requirements and so on, that the issues around upfront payments are problematic. In fact, I'm not certain that it can be made. So we need to understand why is it that it was made. Now I come to the issue around the MOU with the NPA. We entered into this MOU in 2017, 2018. It's 2017, August to be specific. We approached it, the SABC, the NPA, on the basis that we really wanted to understand at what stage are the matters referred to by SIU to NPA. There were some of the issues that we needed to make sure that we are all on one page. Number one, the referral mechanism. Because in the past, this is sort of before our time, in the past matters were referred to, matters of SIU were referred to the Hawks. In some instances, they were referred to the ACTT, and in some instances were referred to NPA. So our law requires us to refer these matters to NPA. There is no provision, although it may be expedient to refer the matters to the police so that a docket is opened and all of that before it goes to NPA, but we have to stick to what our legislation says. So there was this misunderstanding of what is really the appropriate legal mechanism on the referral. I suppose we could have just engaged and showed them our act and said, this is what our act says, and perhaps no need for an MOU. But however, there were other processes. You could call this organizational processes, which we have to put in place just to ensure that we monitor our referrals. And that MOU has in it what is the structure that we put in place between SIU and NPA to monitor the progress of these cases. And also now dealing with the referral, the referral mechanism, even if it was to repeat what's in the legislation. Take away the MOU, Honorable Chair and Honorable Members. Each one of us really needs to do the work as is expected. But really this MOU served as almost like a mechanism to map out the interaction between the two institutions.
All right.
And then approaching the benches across the country. This was the mechanism when we realized that the cases are sort of clocked in the high courts. We were advised that there's a mechanism that we can use. And in fact, it's not only available to SIU. It's available to all litigants. So every litigant has got the opportunity to approach the bench or the judge president or deputy, to ask for what they call case management. And that deals with, as I say, some of the technicalities that could be raised outside of court or dealt with outside of court, so that when it goes to court, there are no delays. So we've made use of that avenue. It's available to everyone. The next one that I've noted is to SABC. Are there any cases you've lost and so on? And then, well, this was referred to SABC, but we've got a comment as well around the freezing of the pension, because we, together with SABC, have done it. And if I looked at our records, and those who have been at SIU before me do attest that this is sort of the first time that we've done it. And why is it the first time? It's, as I said in my presentation, that we keep really thinking on how to do things differently, and how to ensure that we recover. This was one of the ideas that were put on the table by the investigating team, and they pursued this avenue through the court in this instance, and the freezing was granted. This is really, as I said, akin to AFU process, so that when ultimately we recover, there is some funds that we can, lay our hands on. And I've noted the issue around the tax. I need to thank the honourable member on that. We have been engaging with SARS on other referrals that we make to SARS, and this being sort of the first instance, we'll probably need to raise it with SARS on how they're going to deal with it. I do not have a clear answer on that at the moment, because we have not. Thank you very much. We will consider that. The issue around SIU capacity recommendations implemented by the state institutions, including municipalities. We have, in the new value chain that we have now built up, we have created a specific function which will deal with the follow-ups on the referrals by SIU or across all state institutions. So how is it going to work? Once we have submitted the referral, be it disciplinary, NPA, or, well, in this case, civil litigation, we really deal with it ourselves. So that team, amongst others, will go out to state institutions and follow through on what they have done to implement our recommendations. So that we can take that up. The question arose in one of the meetings we heard that, what happens if they did not institute the recommendations. We do take it up. If it's the accounting officer whom we deal with, it's their responsibility to make sure that they institute disciplinary hearings. In case of disciplinary hearing, where they have failed, we take it up either with the executive authority to make sure that they are held accountable. It is expected of every accounting authority or accounting officer to implement. Where they have not implemented, we would like to understand why. If there's a need to assist, we do consider assisting. But in many instances, we have found that the failure to follow up may have really just contributed to this non-implementation. But again, it shouldn't really rely on follow-ups. We expect that once the referral is made, is acted on. But this being the operations that we are in, we need to build in the mechanism to follow up, and we are doing that.
All right.
So, just in the interest of time, Mr. Motswening's claim that was filed, I think that was dealt with as part of the legal response. Appeal against Sikela Kabiso was dealt with. SABC attorneys Werksmans, I think SABC may respond to that. Why was Sikela Kabiso brought in? Chair, I think most of the
I just think the
cases,
one, maybe you have answered it, the time it takes to revise a proclamation.
Yes, I've got that. In this instance as well, we've got agreed timelines between the Ministry of Justice and the Presidency in terms of how long it should take to get a proclamation through. But in cases where we are investigating and we get further allegations that should be included, we put together the amendment or to the proclamation and we take it through. That process should really not take more than 2 to 3 weeks, given the process that the minister has to sign off and the president has to sign off. So that's more or less the timeline that we have experienced. Thank you very much, Chairperson.
All right, thank you very much, Advocate. Mr. Chairperson, SABC responses, please.
Thank you, Honorable Chair. Let me start by the question around the delegation. We note the comment about female representation, but there's normally 4 things that guides the delegation. One is the relevancy and the expertise that are required for that particular agenda that will be discussed. But secondly, we have to contain cost. So we can't have a big delegation because it costs money for us to do that, but also the availability of members. There are instances where people are not available and you have to work with those that are available. But the point is noted. I want to also respond on the question of the security tender. What's the view of the board? There was a question asked on that. The Jaili tender issue was decided by the interim board in the early 2017. So the interim board had a 6 months period at the SABC, and that's when that decision about that tender was made. So when the new board came in, which was inclusive of the interim board members, we then received a number of other allegations relating to the tender. We then decided to request the SIU to investigate. So the decision to involve SIU was taken by the board, which means as a board we're taking accountability and saying, let's investigate the matter so that we can get to the bottom of what really happened. The SIU then came on board and through the second proclamation that was given, they investigated and they've provided us with a final report. That final report was then discussed by the board, and as a board, we are agreeing with what the SIU has recommended as it relates to setting aside of the contract based on the evidence that they came up with around the irregularity of that contract. So as the SABC, we are fully aligned with the SIU on the matter of the tender that relates to that security tender. That's what I would want to cover, and then I want to hand over to the CEO.
What I'm not hearing is that was it the end product, the awarding of the tender itself that had irregularities, or the entire compilation of the tender from the specification up to the stage where it is awarded? That is the problem. If I can just get the clarity on that one. Are you questioning the final product, which is the awarding, or the compilation, and all other contract-related aspects that were involved in compiling the tender that you want to set aside? Because I assume it's not the first tender that you are issuing that relates to securities, and some of the specification that were used before can still be applicable. So I just want to get clarity on that one.
Honorable members, I'll be very limited in the details because the matter is in court as we speak. But what I can say is that the investigation by the SIU look at the entire process, not the decision point, but from what transpired before they got to the decision point. Because there were allegations that certain things were not done properly in the process leading up to a decision by the interim board. But I wouldn't necessarily want to go into further detail because the matter is in court, and I would like to leave it there.
All right, no, it's fine. We'll come back to that, right? You wanted to, all right, CEO.
Thank you, Chairperson. There's quite a couple of matters that have been raised. And I will start with the one on how strong our internal processes. We, as you may appreciate, we're doing two things. We're rectifying past historic issues of the collapse of governance, but at the same time, we're instilling a very strong governance framework and plan. What essentially that means is that even it has to do with behavior, we're looking at issues of culture change, and also to ensure that our actions are aligned with where we want to take the SABC. So to institutionalize accountability and the right way and the values of doing things, it'll take a while, because we have to do both, deal with the legacy issues, whilst ensuring that we prevent these from recurring. In line with that, there was a question on the 186 cases. These cases date back to 2012, and it's some of the cases that were not attended to. Some of them were deliberately neglected, and there is a correlation between these 186 cases and the 5.2 billion irregular expenditure that we recorded year on year. So these are some of the things that we are currently dealing with. The second question that was asked was on the quantum in terms of approvals, to say who approves how much. This depends on whether it's a procurement of services and goods, or whether it is a revenue generation issue, or whether it is investment in CapEx. But general managers, they can approve up to 10 million. Then you have group executives that can approve up to about 50 million. Then EXCO, the group EXCO, can approve any amount between 50 million and 100 million. And the board then approves all contracts that are above 100 million. But there is certainly, in terms of our delegation of authority, every single thing would have to go to EXCO and then ultimately to the board. Then there was a question on the percentage contribution of TV licenses to our overall revenue. TV license collection contribute about 15% towards our overall revenue. And then you have 84%, which is advertising, and then government grants is about 2 to 3%. Then the other question was what is the commission that we pay to the debt collecting agencies? It's in line with industry standard. It's about 25%. And there are two ways we collect TV licenses. It's internal projects as well as the debt collecting agencies. That's why year on year, our revenue generation on TV license has been about 1 billion. And you may also appreciate that there are a lot of factors that are that contribute to that. It could be the economic climate, it could be issues like reputation of the SABC, and also there are issues around out-of-pocket spend from the different households. So there's a lot of issues around that. The other point that was raised was the issue around the what are we doing to boost revenues? We've ensured that over and above commercial, which we get through advertising and TV licenses, we've been able to get into diversified income streams like merchandising. We now have a division, or rather a unit called Adventure. We're also engaging more with government to ensure that we can get the advertising spent. So there's a lot of things, even the eventing strategy that is aimed at attracting more revenue. The other point, the other question was on what are we doing in terms of cutting costs. If you look at the trajectory in the past, I would say 3 financial years, we started at about just over R1 billion on losses, and then we reduced that to 622 million. This past fiscal, we're able to go to 803 million. So there is a trend when it comes to reducing costs quite significantly. The question on the freelancers, we have a staff complement of about 5,500 employees, and 2,000 of those are freelancers. And in terms of the contribution to the overall wage bill, the SABC's wage bill stands at about 45% of the overall expenditure, and that actually the contributor for the freelancers is about just over 400 million of the 3.2 billion. So it's quite substantial, and Ndate Tegiso will talk to how we are trying to ensure there's no duplication, because we have seen that some of the responsibilities of the freelancers are actually done by the permanent employees. So there is a process that looks into that coordination. The issue about sending news crews to different destinations and we end up not using it, this is really an editorial prerogative in terms of the stories that need to be covered on a particular day. But it could also be issues of logistics. If we send somebody to a far-flung area to cover a story, by the time the person comes, it could be that it's not possible to flight it at that moment. But what it does do, it helps us from an archives point of view and ensure that we have the required memory. Sports rights matters. I've said this in different platforms. This is one of the biggest cost drivers for the SABC. We're spending a lot. Certainly, we committed to the public mandate of broadcasting sports of national interest, but it comes at a very exorbitant cost for the SABC. In the past 3 years alone, we've spent about 3.8 billion on sports rights. We've done financial projections for the next 3 years. It'll stand at about 6.8 billion. What we have then decided to do is that any deal or commercial agreement that does not make sense for the SABC, and we're looking here in terms of the expenditure vis-a-vis what we get from a revenue point of view. Specifically to the point that you're asking, Chairperson, on the rights for rugby. For the TV rights, it was going to cost the SABC just over 28 million US dollars, so that equates to about 420 million. And this is for TV. And even then, 60% of the matches were going to be live, 15% were going to be delayed, and the rest we were not going to be able to get those. When it comes to the radio rights, the amount there would have been 90,000 US dollars, and inclusive of the production cost, which would have to incur, it would have been about just over 900,000 rands. So it just is not financially and commercially viable for us, because also the lead time, it's important that we get these rights in good time so that we can develop a sales pipeline to enable us to on-sell to the different advertisers. Just also to give you a sense, Chairperson, last year we recorded financial losses of about 483 million, and just over 400 of those is actually dedicated to the contribution of sports rights. So we certainly are committed to fulfilling the mandate, but in doing so, we want to make sure we get in deals that are commercially viable for the SABC as well. If I may, Advocate Vanara, Chair, would then take
No,
that
that's
take.
fine.
So. Thank you.
Thank you.
Thank you, Chair, honourable members, and the Deputy Minister. With regard to the irregular appointments, Chair, honourable members might be aware that the SABC is currently in front of the Labour Court on the same issue of irregular appointments. Some of the respondents in that application would involve the names of people appearing on both our report to the committee and the SIU report. So when I made the earlier comment around the discussions between the SIU and the SABC, it was not necessarily to say there's a conflict. It was from a technical legal issue important for us to record those discussions. And the SIU has clarified the issue. The case is lost and the amounts involved. Insofar as the presentation of today, there's only one matter that both the SABC and the SIU in the joint litigation have lost, and that is the Segala Klabiso one, which has been dealt with at length. If the committee want other cases over and above these, I think we will have to prepare a report and submit it to the committee. However, I know of no lawyer that has not lost a case except a lawyer that does not litigate. So you win some, you win some. But what I can assure the committee is that there is due diligence before decisions are taken on whether or not to engage in litigation. Such decisions are informed by what would ordinarily be legal precedents on matters that would have served before different courts. It would be informed by our economic situation. There will be a cost-benefit analysis done. But when all these matters have been considered, a decision will then be taken. With regard to the usage of the studio, there's a question that was asking what is it that we're looking for with regard to the studio, which is the Vision View matter. With the Vision View matter, the SABC had already paid 34 million at the time of this matter becoming a subject of the SIU investigation. You would recall that this matter became a subject of the ad hoc committee inquiry, where allegations of impropriety were labeled towards this particular transaction. The non-use of the studio, having paid 34 million, is tantamount to a fruitless and wasteful expenditure. And to compound to that situation, the SABC, given its financial position, couldn't maintain some of its other studios. And a decision collectively was then taken to say what are the legal challenges if we were to utilize the studio. And the decision was then taken that we should utilize the studio. What we are looking for, as I indicated earlier, we wanted, because there was no procurement process followed here, we are not certain that the amount agreed to was a market-related amount, which is the reason that the court said we needed to, having decided the matter, go back to arbitration to have resolved. That was number one. Secondly, it was the issue of the percentage completion of the studio. The SABC was of the view that the studio completion was around 88%, and the service provider was of the view that the studio was around 96% completion rate. We, in an attempt to resolve this issue, we tried to, notwithstanding the court order, notwithstanding our anxieties around the correctness thereof, we tried to engage the service provider out of those arbitration proceedings and to avoid the appeal. But unfortunately, those processes failed because we were of the view that the amount the service provider wants is not a justifiable amount, having done our own calculations. It is for that reason that we've then decided to appeal this matter. On the tax implications of the pension withholding, I'm no tax expert. I can't provide a response to this, Chair. But what I can say is what we know is that this provides crucial cushion for us not to sit with hollow judgments. When a matter or when the judgment is given in our favor to recoup an X amount of money, we know that there is a safety net. It might not cover the entire debt, but we know at least there is some money sitting somewhere that we could recoup. The last issue relates to the panel of attorneys, whether Werksman's attorneys in that panel, and the rotation inherent in that list. I can confirm, one, we do have a panel of attorneys, service providers. Secondly, I can confirm that Werksman's is part and parcel of the current panel of service providers. And thirdly, that since joining the company, I've ensured that there is a rotation of the attorneys that are serving in the panel of attorneys. The last issue related, Chair, to the internal investigations, forensic investigations, vis-a-vis the investigations conducted by the SIU. The SIU, as indicated eloquently by the head of the SIU, they're a creature of statute. They investigate matters that have been referred to them through a proclamation by the President. In other words, the SIU does not babysit each and every institution to monitor each transgression within that particular entity. That is why, in terms of good corporate governance, you have internal audit, having the forensic investigative capability within the organization to deal with issues of whistleblowing, to deal with referrals of allegations of misconduct that get to be investigated internally by people who understand the business. Secondly, without incurring additional costs in terms of the conduct of those investigations. That then is my contribution, Chair.
All right, no, thank you very much, Mr. Chairman. I think that we have arrived almost at the end of our meeting.
Mr. Chairman, just one last question that I didn't get an answer for, and it's a quick one. In terms of possible increases to TV license fees, is that under consideration as a way of raising additional?
Thank you, Chairperson. As indicated by the CEO, TV licenses is a second biggest stream to our revenue. It gives us about 15%. Following on the commercial, which gives us about 84%. Then the third one is government giving us 3%. So where we are, we've put a request to the ministry to request the review of TV license, because when you look at where we are now, South Africans are only paying about 72 cents a day for a TV license, considering what SABC gives you, which is about 19 radio stations, 5 TV channels. And our view is that we need to review the TV license so that we can increase it, because it gives us quite a substantial amount of money. That request is with the ministry as we speak.
What is the increase amount?
Maybe say what's the amount of you've requested? I think. Yeah.
I'm not sure of the amount. Let me just check. The CEO is informing me that it's around about 5% increase.
Okay, Mr. Lisa, are you fine with that? All right. I still don't have a TV and I'm now pay 5% extra. Oh, nothing. Right. Chair, you know, there was a question about the representation of the board complement. I think we should have asked who's here. My memory serves me well. That lady at the back there is a board member. So I just wonder why she's not seated here. I've been cracking my head the whole time, and it's only when you responded. So I'm answering on your question, but what's going on? I'm like, I don't know, like the whole time I'm sitting here, and you know, thanks to Google, you know.
Chair, with the experience of SABC, Chair must tell us, in case he's carrying a whistleblower within his board. That's the experience we're having with SABC board, Chair.
Yeah, it just doesn't augur well.
It doesn't,
you
Chair,
know,
at all.
It does not sit well with me at all. So I'm sitting here, I'm thinking, no, man, you know, I've got a very good facial recognition. I'm bad with names. But, Deputy Minister, I just hope you see this. For all intents and purposes, it says a lot without saying anything, but it speaks volumes about what we are dealing with. So, yeah, I really, I'm not sure what to make of this, but I think it's something we must look at in terms of due process. I just want to, okay, then, Honorable Kadwanara, you spoke about the issue of the cases that yes, lawyers lose, that's common cause. You win some, you lose some. It's like breathing in and out. So you've spoken about the contracts. I'm interested to know the extent to which, how many cases in terms of your DC processes have you lost and are appealing? And the cost factors involved in that. So if a schedule of those can be provided, the matters which are before the Labour Court, CCMA, how many of them you are appealing, that will be helpful. So that we can dispense with that particular one. And then there's the issue of the referrals, the phase 2, which I think it is, which was referred to in the SIU report. It starts with, whilst I find that page, on the issue of freezing, whilst the hope is that it provides a safety net for us to make recoveries, the question becomes, what happens when you lose and you've frozen someone's pension for a while? There are those cost issues and consequences to consider as well, the flip side of that coin. So I think that is a consideration that must be made. The initiative is good, but it's not without risks. So I think let's speak to both the pros and cons of this particular arrangement. I say this not to take away from what I see as a positive step, but I would imagine that if you have frozen my pension and then I win, I'm probably going to pursue you for the years in which, or the months in which you have inconvenienced me. So that is something to look at. I'm just trying to find that page. See this paper mill. I'll come to it just now. It's a schedule of the phase 2 of the referrals. But in any case, the point I'm trying to get at with that one is if we may be provided with monthly reports on the progress of those referrals. We would want to interact with the NPA on the progress they are making on these cases. Yeah. Oh, where was this on? Yeah, it's on page. It's item. It starts on 31. Some steps are being taken by the board, as the SIU was saying. I mean, there's that TNA. A lot has been said about the SABC security contract of 194 million. But there's 144 million rands as well. I mean, so far as the new age is concerned, I think it would have been beneficial if that was spoken to at length, the circumstances around that. And then the report, please, on the 180 forensic reports, the action steps being taken on each one and what arises out of that particular issue. I think we will have another interaction with the SA. I get my tongue twisted all the time on this. The ACTT. When we engage advocates, can we flag the issue with the NPA on the bottlenecks on this particular, so that we've got everybody in the room on that particular day, and we finalize and tie down on that particular aspect. Deputy Minister, I will come to you, and then we will conclude. So if there are any comments that you would like to make, Deputy Minister, I will now hand over to you, and you can briefly interact with us. Understanding that today, of course, we are 2 o'clock, not 3 o'clock, so there are those considerations as well. Right, dear?
No, thank you very much, Chair, and let me also thank all members, honorable members of the Standing Committee. Chair, we take all the issues that the members were raising as work in progress. But the message we're getting from Scopa is that the SABC has to open a new chapter. And stealing from your words, Chair, is to say we have to inspire confidence back into our public through our public broadcaster. And I think as the shareholder, we're committed to that. There are a number of things that the members have raised, and fortunately tomorrow we have the AGM at the SABC, so some of these issues will factor them in, so that by the time we come back to Scopa, we'll be able to bring progress. Of course, there may be issues that we may share with Scopa in between, even before we come to another engagement with Scopa, that through the chairperson and the CEO can be facilitated so that it's sent through to you. Chair, I think from where we stand as the shareholder in the SABC, we really have to apologize. And I think the representation of delegation should not be negotiable. Women should be there as a delegation. It's something that will correct, because we need to expose every member of the board on the proceedings of Parliament, on what is expected, and so on. So the delegation will for sure take care of the women delegation. Chair, we are committed to the stability of the board and the entity itself. I know you raised the issue of things being perennial, and from where we're sitting and the report that Advocate Varana is giving will surely register progress and make sure that things happen accordingly. We're looking forward to what the Advocate Mutibi was saying around the special tribunal. We hope it will assist to fast track some of the things, the outstanding cases that are confronting us, so that we open a new chapter in the SABC. Thank you very much.
Right, colleagues, I think we have come to the end of our engagement. I do want, Advocate?
Before you close, it's unrelated to the SABC matter. I'm told before I came in, we were requested yesterday to have a list of municipalities that we're investigating in. We've got it. I've got a hard copy, but I'm told that it may have been raised. We can still submit it formally to the scope.
No,
but
that's fine.
we did compile it.
All right, no, that's fine. I'll respond to that, Deputy
Chair,
Minister.
even on my side, you raised the issue of the board member.
Yes, and the
I will engage
steps
with
being taken to
with the
investigate.
SABC, and then we'll revert back to you.
All right.
Thank you.
On all these things that we have requested, even though Parliament is going on recess, our administration is not. So today being Wednesday, I think 7 days would be fair, because members do know that they have to be reading in any case. So if we can get all the issues we have requested next week, Wednesday, 12 o'clock. On the issue of municipalities, the point was succinctly made that we've got municipalities that received disclaimed or adverse findings for a period of 3 years or more. 14 of them, we have had hearings with them, and what we want to do is develop a roadmap in terms of the referrals for those. But I relate the information, so the deputy head is aware of them. It was just a matter of handing over the names of the municipalities, and then we can have a look. But we can receive the issue, the list that you have, because we really want to tie down on the issue of municipalities, because I think for the longest of time they've become a runaway train.
Mr. Chairman, just quickly on that municipal one, you will recall that there was a request for us to intervene with Tabazimbi, because the SIU has been involved in it for 2 years in investigations there, but a report hasn't been produced yet or hasn't been made available. So if we could.
Yeah, maybe what we can do, let's get the SIU list, we give them our list, and then we'll have an engagement and compare and exchange notes, because what we really want to get at is an investigation on that particular aspect. Because you see, this record keeping, which is fast absent in municipalities, is what is giving rise to disclaimers. It's a deliberate, action step. I just want to, in conclusion, colleagues, thank you to SABC, Mr. Chairman, and your team, Advocate and your team from the SIU, Deputy Minister, Auditor General. And I want to drive home the point, Chair. There must be unity of purpose and coherence in the manner in which we do things, and avoid at all times, at all material times, which is all the time, a situation where we present an image and a perception of an institution which is not in sync internally. We have got no friends, we've got no enemies. Our only concern is the rands and cents. And we look at the environment in which those rands and cents are spent, and in the main it's made up of individuals, people relations. And therefore it cannot be that we off the bat in a manner which calls into question what we are doing. So, Deputy Minister, I request that you look at this matter. It does not sit well with us at all, particularly in line of the question that Honorable Tolashe raised. That's what triggered my inquisitiveness. It does not at all. We want to see the SABC turn around. Particularly those of us who come from rural communities, emakhaya lemfume, where Umkhulu Dlamini is dependent on radio to understand what is going on in the world around him. And for him to understand and to be in the loop, he needs a functional SABC. So this is also about national security. It's about the collective sustainable livelihoods of our people. It's about dispensation of information. So it's important that we do the right things for no other reason than them being the right thing. And chief amongst that is consequence management, which sees people walk the plank so that we can be able to turn things around. So we are seated here with no other interest other than ensuring that things are right. So we will be communicating with the SABC again on when we will meet. There's the issues of fruitless, wasteful and irregular expenditure which we must still deal with. We still have to look at the Sailor Klabeso report, whatever the circumstances of that tender was, but work was done. And we need to juxtapose it to work that was already done in the institution. So, as Honorable Tolashe said, SABC remains firmly on our purview. We have agreed as a committee arising out of our legacy report that we are adopting SABC amongst many other institutions that we are adopting. So it seems with each passing day we are unloading more, but we appreciate you being here and we appreciate the interaction we have had. It helps us understand the space we are overseeing and holding you accountable for better. So we wish you well and we will be seeing each other soon. Colleagues, this is our last meeting for the term. The only request I'll have is that you make input to the draft report on ESCOM so that first off the bat when we come back we tie it down on that because there are quite a number of recommendations that we need to make. We'll finalize the municipal report and the ESCOM report when we come back and you will receive our recommendations. If you see us at SABC, just know we may pass by formally or informally for an oversight. But I think working with the Portfolio Committee on Communications, we will make it a point that we come back. The chair knows we had, the previous Scopa did go. We will be paying a visit to SABC, but maybe not to Auckland Park in another jurisdiction, because sometimes we spend too much time in Johannesburg and lose sight that SABC is present everywhere. So we want to also look at those spaces where you are operating from. So it helps me sleep at home. On that note, colleagues, the meeting stands adjourned. Thank you.